chairman of ASAS for the Eastern region, also the head of human resources for Steel Brands. Thank you.
Good morning. The name is Monorway Willis. I'm the Provincial Labour Officer for Harare Province for the Ministry of Public Service, Labour and Social Welfare. Thank you.
Good morning to you all. I'm Tsitsi Mazikana, Managing Partner for Lunga Mazikana Attorneys.
Good morning, everybody. Matthias Rosa is my name, Secretary General of the Engineering, Iron and Steel Association of Zimbabwe. Thank you.
Good morning, everyone. My name is Advocate Benjamin Magogo. I'm an advocate with Advocate Chambers. Thank you.
Morning, everyone. My name is Mrs. Chiedza Chigombe. I'm Director for Kubota Engineering, incoming President for ACES. Thank you all.
Thank you. Let's give a round of applause to ourselves for getting to know each other. We certainly need to unpack this Labour Amendment Act, and I know we've been following it. We've been following it since it was first approved by Cabinet in terms of the principles in 2021, and it was gazetted, and we've had this bill being discussed until recently it was enacted. So what are the implications on labor? What are the implications on organizations? And today is that event to unpack this new amendment. And so to kickstart today's proceedings, we would like to open up for welcome remarks, and these remarks will be given to us by Mr. Mathias Ruziwa. Mathias is a key part of the Engineering, Iron and Steel Association of Zimbabwe as Secretary General. He's a business and labor expert with over 20 years of experience in the private sector. He has served in various leadership roles at the Confederation of Zimbabwe Industries, Institute of People Management of Zimbabwe, NEC for Engineering, Iron and Steel, Standards Association of Zimbabwe, and he's a certified independent arbitrator by the Ministry of Public Service, Labor and Social Welfare since 2012. He holds an executive master's in business administration from the Midland State University, among other qualifications, and he's Chief Executive Officer as well as Board Secretary of the Strategic Leadership Association of Zimbabwe, Engineering, Iron and Steel Industry, this organization that we launched a month or so ago. He has served as Secretary General of the Engineering, Iron and Steel Industry since 2017. Ladies and gentlemen, help me welcome Mr. Mathias Ruziwa.
Thank you, Director of Ceremonies. Allow me to recognize the Provincial Labour Officer for Harare Metropolitan Province, Mr. Munorwei. Allow me to recognize the Principal Labour Officer from the Department of Registration, Ministry of Public Service, Labour and Social Welfare, Mrs. M.T. Mapfaka. Allow me to also recognize the incoming President of ASAS, Mrs. Chiedza Chigombe, Mr. Austin Tigere, immediate past President of ASAS, our regional chair here, President Mr. Christopher Mushiwo Kufa, ASAS members, senior government officials are here present, captains of industry, fellow human resource practitioners from various sectors of the economy, representatives from academic institutions. I take note, we have the University of Zimbabwe, we have Chinoi University of Technology, as well as Manicaland State University. representatives from the League of Fraternity, leaders and representatives from various national employment councils, NEC for catering, Mr. Bore and your team, thank you for coming. NEC Zinwa, Mrs. Nozipo Smango, NEC Engineering, Iron and Steel, Mr. Nyamatore and your team. NEC for tourism and hospitality, as well as NEC for ferroalloy industries. Thank you all for coming. Allow me to also recognize representatives from employee representative bodies. I have seen Mr. Sfelan Masukume, Secretary General of James Tauzi, Mr. Stanford Magadu from Pem Tauzi, as well as Mr. Anthony Nyashanu, President of Nemauzi from the ferroalloy industry. Thank you for coming. I would also like to acknowledge our esteemed sponsor who has partnered us for this event, the Engineering Medical Fund. Conference facilitators, Advocate Benjamin Magogo, Madam Tsitsima Zikana. I'm sure Senior Counsel Caleb Mcheche should be on his way. Conference hosts, the Crown Plaza Monomutapa, our friends from the media, distinguished guests, ladies and gentlemen, good morning to you all. It gives me immense pleasure to start this occasion by heartily welcoming everybody on behalf of the Engineering, Iron and Steel Association of Zimbabwe to this workshop specifically organized for unpacking of the Labor Amendment Act number 11 of 2023, which became law on the 14th of July 2023. ASAS is a body duly constituted and registered in terms of the laws of Zimbabwe to represent the interests of employers, particularly in the engineering, iron and steel industry. We have been in existence since July of 1937, serving employers' interests in such areas as industry strategy and development, as well as implementation, advocacy and lobbying for relevant business policies, collective bargaining, research and analysis, and we do play an advisory role in business, economic, and labor matters. Ladies and gentlemen, it's terrific to see so many familiar faces, some of whom I think have attended most of our workshops over the years. But it's also pleasing to see so many new faces here this morning. We have close to 150 delegates from various sectors of the economy, which include telecommunications, air transport, mining, the motor industry, medical, banking, construction, ferroalloys, funeral, tourism and hospitality, pharmaceuticals, Zinwa, etc., etc. So the social capital opportunities are available at this workshop, ladies and gentlemen, should not be wasted. It is indeed a great pleasure for me to be here today and to welcome you on an area which ASAS is very passionate and have spent many years seeking to promote and sharing knowledge and advance the labor relations system in our beloved country, Zimbabwe. I therefore wish to thank all of you for considering this event as important as I do by your very presence. Ladies and gentlemen, I would like to place on record sincere appreciation to our line government ministry, the Ministry of Public Service, Labor and Social Welfare, for their unwavering support at this occasion. Mr. Munorwese, Madam Mapfaka, we really thank you for coming. We have witnessed that the last four years have seen labor administration as a highly contested arena in view of our nation's quest to address the competitiveness deficits and challenges that impede our socio-economic transformation. We would like to thank the government for remaining committed to striking a balance between labor market efficiency and decent labor standards. We commend your efforts together with the social partners, business represented by MCOs, as well as the employee representative bodies, the ZCTU and the ZFTU, for undertaking to amend the labor law and promulgate new legislation that is relevant to the world of work in Zimbabwe. We know that the consultative process was extensive, and we are now happy that your splendid efforts culminated in promulgation of a new Labor Amendment Act, giving evidence that the development of labor law in Zimbabwe is not static. We are also very grateful that the International Labour Organization continues to make concerted effort and support to institutionalize social dialogue under the tripartite negotiating forum. Now, as I stated at the beginning of my remarks, this workshop is specifically designed to let participants have understanding and appreciation of the new legislation. Just for a brief background, following the consultations among representatives of government, business, and labor within the auspices of the TNF, our legislators in the Zimbabwean Parliament and the Senate were guided by principles that govern the route that an amendment should take to cure the anomaly in existing legal principles. Some of us may recall that 13 principles were identified way back in an effort to establish the amendment in year 2015. Unfortunately, what then happened in 2015 was that the labor law reform was then rushed because of the famous Zuva judgment. 8 years later, these principles formed the basis of the Labor Amendment Bill, which was promulgated in 2021. Out of the 13 principles that were identified, 37 clauses were put in place in a bid to come up with the Labor Amendment Bill. The agreed principles sought to harmonize the Labor Act with Section 65 of the Zimbabwean Constitution, as well as ILO conventions ratified by Zimbabwe. Furthermore, the principles also sought to promote ease of doing business through streamlining processes in such areas as retrenchment and labor dispute settlement. The Labor Amendment Act number 11 of 2023, enacted by Parliament and the President of Zimbabwe, has amended 28 sections of the Labor Act, Chapter 28.01. It has repealed one section and inserted seven new sections. May I, at this juncture, thank each of our facilitators for accepting to take part in this workshop. The quality and caliber of the labor law experts we have invited to unpack this Labor Amendment Act 2023 is outstanding. We are so thankful to have with us this morning senior labor law expert is yet to arrive, Caleb Mucheche from Caleb Mucheche Law Chambers, Advocate Benjamin Magogo, an advocate of the Superior Courts of Zimbabwe, and Ms. Tsitsima Zikana, a managing partner at Lunga Mazikana Investments and Corporate Attorneys. They are uniquely placed, ladies and gentlemen, to speak on various amendments to the Labor Act. And our program has been designed in a manner that will allow Advocate Magogo and Ms. Mazikana to give us insights and interpretations on various sections envisaged in the Labour Amendment Act. And before we break for lunch, Mr. Mcheche will unveil to us the advantages and disadvantages of this new legislation. I was talking to one delegate just before we started, Director of Ceremonies, and she was saying to me, what are the advantages for employers as far as this legislation is concerned? And my response was to say, please wait, Mr. Mcheche will deal with that before we break for lunch. The legal team led by Mr. Mcheche will attend to all your questions after lunch. It's a full day workshop running from 8 a.m. to 3:45 p.m. So as the speakers take us through the various provisions enshrined in the Act, please jot down all your questions. And for those with the interventions, there will be ample time after lunch to share knowledge and deal with relevant areas that need clarifications. So please, I plead with you not to leave the workshop prematurely. In some cases, immediately after people take their lunch, they then disappear and go back to where they came from. We want everybody to benefit from your invaluable knowledge and contributions. So, ladies and gentlemen, a very warm welcome to each and every one of you. Let me once again thank our fantastic facilitators for giving their time and legal insights today. I sincerely hope you are all going to enjoy the workshop. Thank you very, very much.
Thank you for those opening remarks by the Secretary General of ACES, just setting the tone and highlighting the complexity of the labor market in Zimbabwe, especially since that Zuva case in 2015. But we now have this Labor Amendment Act, and hopefully we can benefit as a country as a result. Now, moving on now into the detail of this Amendment Act is the next part of the program, and to take us through is Advocate Benjamin Magogo. He is an advocate at Chambers, and he's also advocate of the Superior Courts of Zimbabwe. Now, as you can see on the program, specific areas of focus will be the interpretation of the Act, prohibition of forced labor, protection of employees against discrimination, protection of employee rights to fair labor standards, unfair labor practices by the employer, employment of young persons, amendments specific to that section. Now, just a brief background of the advocate. He graduated with a Bachelor of Laws degree, honors, from the University of Zimbabwe in 2011, joined Matsikidze and Mcheche legal practitioners in 2011, before moving on to Senior Law and Partners in 2013. And then in January 2015, he established his law firm, and he formed his that partnership, Makwaza and Magogo Attorneys, in 2015. And on the 4th of January 2021, he was admitted to practice as an advocate of the Superior Courts of Zimbabwe, based at Advocate Chambers in Harare. During his has shown keen interest in labor law, and for your information, he's happily married to Primrose, and the couple have 3 children. So, yeah. I just needed to emphasize that he's happily married. So if any of the ladies are impressed with his presentation, there is no room. A round of applause for him as he comes through.
Thank you, Kumbirai. What an introduction. Thank you for telling them that I am happily married. It hasn't changed. Still that fine. Thank you. Ladies and gentlemen, I am honored to be here. And I would like to acknowledge the presence of the leadership at ASAS, Mr. Ruziwa and Tim, for extending the invite to me, Mr. Norway and the team from the ministry. Thank you very much for allowing us to speak while you are here and listening. We are so honored to have you around. I had Ms. Mapfaka Samwe. She's always there when we talk labor. And a couple of other individuals from the ministry. I mention them specifically because they are the drivers of processes like these, and whatever else comes from the labor process, pros or cons, they should know, and they obviously would have to attend to any issues that arise. We will generously talk about the amendment now that it's law. And as lawyers, you will bear with us. That's why I started with the people from the ministry. You bear with us sometimes when we speak strongly, I don't want to say harshly, about some of the provisions that are in the amendment. But you also smile when we tell you of some of the provisions that we think quite good for us as a country in our labor sphere. So we thank you so much for being here. All guests from several, I listened, I couldn't take count of the respective organizations that are represented here. I just want to acknowledge all of you and to indicate that I feel very much honored to be standing in front of you and to be speaking to you. I will be speaking a lot today, I think, as the program illustrates, and I'm just hoping that by the time I'm done, you would not have gotten fed up with me. Okay, so somebody will be helping us to go through this. So I've been asked to unpack the new Labor Amendment Act. I think it's important that we understand what is being done here, and the nature of our program clarifies it, that this morning, I think right up through to lunch, we're just trying to tell each other what is in the Act. What does it mean? And so I will restrain myself as much as I can from trying to maybe give gratuitous comments on perhaps what I think about some. You will notice that as I was preparing the presentation, I was trying to do that, but in some cases I failed to restrain myself. So you will see certain stuff that is italicized, which speaks basically to my thoughts on some of those issues. So we will try and rush through the issues so that we all get what we have to get. So by way of introduction, I think we've been told that this process of amendment started in 2021 when HB 14 of 2021, the Labor Amendment Bill, was gazetted. Processes which are prescribed by law relating to the legislative process then occurred, and it saw a lot of proposed changes to the Labor Act in the bill falling away, such as the provision on labor broking, capping of fixed-term contracts, etc. I think you recall, or some of you may have attended certain seminars and workshops when the labor bill was being discussed. You recall that there were certain provisions, such as labor broking, certain provisions such as capping of fixed-term contracts. I had Ms. Mango somewhere. Yeah, she called me some other day saying, what are we going to do about my fixed term contracts? I think she's one of those persons we should be glad to know that that provision did not see the light of the day. It's not bad. So there are issues that we actually taken out. As to at what stage they fell out, I may not be aware, but at the end of the day, what we have is the law, and we will speak to it as it is. So if there is anything for any one of us here who has perhaps read the bill or attended the bill workshop where the bill was being discussed, that you still think should be there, or you feel that hasn't been talked about, please feel free to raise it. It could also be one of those issues that did not finally see the light of day in the Act. So eventually those processes culminated in the gazetting of the Amendment Act number 11 of 2023, which, as we now all know, is now law. So my presentation in terms of structure, ladies and gentlemen, will go like this. You will notice in terms of the program, I'm supposed to speak to everything in the amendment except sections 1293, 101, 109, 111, and 112, which my learned counsel and colleague Tsitsima Zikana will speak to. So I've broken my presentation into 6 segments, those segments that you see on the program. Each section represents a particular segment, and how I'm going to do it is that I will be referring to sections as they are currently in the Act. So I'm not going to be referring to sections of the Amendment Act. I'm not going to be saying Section 24 of the Amendment Act. I'm going to be referring to the sections of the Labor Act as we know it. I just thought I could clarify that so that we don't lose each other when I'm going through it. So let's go straight into the first segment, which should have 30 minutes. Maybe you can guide me how many minutes I have. Okay, he says it's actually less than 30 minutes. Now, so what the this segment has done, or what this amendment on this section has done, is it has given us a new definition of the gender-based violence and harassment. I think it's an important issue that has for some time not found its way into the statutes. Now, the statute has defined 2 terms: violence and harassment, and gender-based violence and harassment. So this is an amendment of Section 2. You notice in our Labor Act, Section 2 is the definition section. So we now have a definition of violence and harassment. Some of you had these in your codes of conduct and so forth, but we now have a statutory definition. And I want you to look at that definition quite closely, because I think it has issues that are quite pertinent. And it is defined as follows in the context of Section 6.3 and Section 8. So Section 6.3 highlights fair labor standards, and so you find relevance of this definition when you are looking at what are fair labor standards, and also Section 8 of the Labor Act, which deals with what are unfair labor practices as committed by an employer. Now, it refers, so in the context of those 2 sections, violence and harassment refers to a range of unacceptable behaviors and practices or threats thereof, whether a single occurrence or repeated, that aim at, result in, or are likely to result in physical, psychological, sexual, or economic harm, and includes gender-based violence and harassment. I will quickly speak to the words or phrases that I've highlighted, that I've underlined, so that you understand the importance or the import of this definition. So much that happens at the workplace today may find itself categorized as violence and harassment. Why? Because this definition now says any unacceptable behavior that is likely to result, not that will result, any unacceptable behavior that is likely to result in a person getting physical, psychological, sexual, or economic harm, that is violence and harassment. And then it also goes on to say, or threats thereof. So it may not be actually unacceptable behavior that is okay, but you've just threatened that I will do this to you. If that is likely to result, get that right. If it results in harm, then it's an aggravation. But it simply says that is likely to result. And so even outside the context of gender-based violence, just that on its own it's in my view very all-encompassing, and we need to understand it even as we go to our workplaces, what that definition brings there. So I indicate that you can actually have everything be referred to as violence and harassment. And so that definition then includes gender-based violence and harassment. And then gender-based violence and harassment is then defined separately to mean violence and harassment directed at persons because of their sex or gender, or affecting persons of a particular sex or gender disproportionately, and includes sexual harassment. So I think this one then zeroes it into sex and gender, but it takes again from the main definition of violence and harassment. So I think that is where the issue is, and we need really to be very watchful that this is not an issue that only affects women. It's an issue that it can affect men as well. Let's move on to the next slide. So we now have an amendment of Section 4A of our Labor Act. That amendment is just meant to introduce, in terms of our constitution, forced labor is unlawful. In terms of our Labor Act, Section 4A had actually outlined that forced labor is not allowed, but there are exceptions that are given. So this provision, the amendment repeals the whole Section 4A and introduces a new one, but that amendment reproduces some of the things that were there, but adds under exceptions to forced labor, work or service which forms part of the normal civic obligations voluntarily undertaken by citizens of a fully self-governing country is also exempt from forced labor. So your civic obligations, community service, and all these other things that could be done voluntarily that cannot be categorized as forced labor. You also understand that the Labor Act, as before the amendment and even after the amendment, gave as an exception forced labor that could be done, or work that could be done in time of emergencies or disaster. So the new amendment has reproduced that, but has added a further leaf to it, which is that in cases of such emergency or disaster, there should be a law that then governs how certain work which is not regarded as forced labor can now be done, and it say the amendment then says that such law that regulates the carrying out of exempt work should set out the circumstances in which its application is reasonably justifiable, should be restricted to the period of the emergency or its immediate aftermath. I think if you recall very well, during the COVID, or just as we were getting out of COVID, there were discussions as to when should we get out of these restrictive measures, when should we get our liberties back, and so forth and so on. So that is part of the issues that arise to say, even if a statute allows you to be allowed to work during emergencies, just to ensure that we take care of each other during that emergency, there must be specificity in the Act itself as to when it ends, and it should be proportionate. And this, I highlight that it is in giving effect to Section 86, subsection 2 of the Constitution, which allows or which gives the criteria for the limitation of rights and freedoms. Forced labor is one such right which is given, but it's not absolute. It could be derogated from, and so the issues to do with, is the exception reasonably justifiable? Is it restricted to a particular period or its immediate aftermath and stuff, are part of the test that is used to see whether or not an amendment is reasonably justifiable in a democratic society. So our Act, in my respectful view, gives effect to that constitutional imperative. Let's go to Section 5. So Section 5 of the Labor Act, of the new Labor Act, is now giving us an expansive provision which broadens the scope for the application of the principle of equal pay for work of equal value as between male and female workers. I think this has been a no-brainer, but the provision just needed to be expanded in such a way that it leaves no doubt. I for one, was thinking that we were okay as we were, but you notice that the statute is actually then ring-fenced as much as it can. So the existing 2A, subsection 2A was removed, and you now have a new subsection 2A, which repeals that provision and says every employer shall pay equal remuneration to male and female employees for work to which equal value is attributed without discrimination on the grounds of sex and gender. I think we can now all relate that there's no justification as we stand now that people who are similarly qualified can get differential payment simply because of their sex or gender. So that is what that provision does, and I think that should be clear. Maybe while I'm still here, as you are relating to my slides, just to guide you a little bit as to my references to the sections. So if I put a small s like that, that is section. And then that's the section number. If I put double S's like what I do in the second bullet, that is subsection, so that you don't get lost, okay? That is what I consistently do in that presentation. Then section 6, remember I indicated earlier on that there is now a definition in section 2 that defines violence and harassment. And that definition, if you recall, it says in the context of section 6, subsection 3, and section 8. Now, section 6, the current section 6, or the section 6 before amendment, did not have a subsection 3. Now, this amendment has introduced a subsection 3. What does that subsection 3 does? It introduces a new crime and act of misconduct, which is called violence and harassment. So violence and harassment, ladies and gentlemen, is no longer just a misconduct. It's a misconduct, it's also a crime, which is actually specified in this amendment, which can be committed at work, on the way to work, it can be committed online, it can be committed on work-related trips, etc. So most codes of conduct had this, but now you have a statute that says if you are going to Victoria Falls or Nyanga for a work-related trip, if you commit those acts that we indicated, that unacceptable behavior likely to cause any person harm, then you can't defend yourself by saying, but we were not at work, we were in Nyanga. It's a work-related trip. If you do it on WhatsApp, if you do it on Facebook, the statute is clear that you can still be charged. So it's a very expansive definition, particularly for HR people who are dealing with misconduct. It's something that you really need to know. But you also need to understand the criminal connotation of that definition. And this is how serious the statute or the legislature thinks about that. So it gives up to level 12 fine or 10 years imprisonment if convicted. It's not something simple, I think, as you look at it. But the worry, maybe we'll discuss it when we get to the plenary. Let me not forestall that discussion. So the misconduct charge and dismissal. So it's a misconduct charge, and the statute says it is a dismissible offense, whether or not you have been taken. Because there are some people who say, if you say I committed fraud, why didn't you report me to the police? Or you took me to the police and I was acquitted. Whether you've been taken to the police, you've been acquitted, or you've not been acquitted, that on its own does not absolve you from facing the misconduct charge and from getting dismissed for it. So it's a serious offense which is introduced, and we need to be careful about it. So that's violence and harassment in section 6. Then we also then have violence and harassment as an unfair labor practice. So you now know it's a crime, it's an act of misconduct, and section 8 introduces the unfair labor practice tip. So engaging in violence and harassment by employer, I underline by employer deliberately, as defined in subsection 2 and 6, now an additional layer of unfair labor practice. So if you go to section 8 of the current Labor Act, it outlines unfair labor practices by the employer. So this is added. Violence and harassment, as defined in section 6.3 and as defined in section 2, is also now an unfair labor practice. But what is fascinating about it is that it is violence and harassment committed by the employer. And so if the employer does it, then the employer also is in trouble. It's interesting how employers refer to and whether liability for the commission of such offense as listed in subsection 2 and 6.3 by individual can be attributed to the employer. So it's an interesting one. Maybe we'll discuss it again in plenary as to if a manager does it to an employee, can the employer be found liable for that, or if another employee does it to another, to what extent can the employer be absolved from it? So it's a potential litigation site, this one, if I look at it. It's most likely going to give us a lot of litigation. Some of you would be aware of the Ritambata versus CZI sexual harassment litigation, which is dragged on and is still rambling on in our courts. I think if that case had happened with this kind of a definition, we'll be talking of something different now, because the courts have accepted, the High Court and the Supreme Court, that there was sexual harassment that she faced, and we are now at a stage where she's actually then quantifying damages for that. So if the statute had been worded like this, I'm sure it would be a different case altogether, and that could have been an inspiration for the amendment. It was mainly because there was so much of this sexual harassment that was happening, but a lot of our managers were escaping because it was not in the statute. So what you HR guys do when you're interviewing people, and how you prefer others and not others, and so forth and so on, those could be issues that really can be categorized as violence and harassment. So the best thing that you can do is stay away from people, isn't it? Yes. When you hire people, please use their CVs, not their structures. Because you may find yourself, because it's something that is likely to cause psychological harm to a person. So if we go in there, it's 5 of us, I feel that I'm more qualified, I feel that she is not qualified, but you have chosen it. And I'm home and 2 days depression, thinking, why did I lose it? I would sue you guys for violence and harassment and other things. But I'm saying this is something that is going to cause, in my view, serious litigation that's coming. So it's an issue that you must take seriously as practitioners. Okay, let's go. I think this should be our last slide on this segment. I've done well, haven't I? Yeah. Employment of young persons, section 11. I think this one also tells us the seriousness of our legislature on issues to do with forced labor. Child labor penalty has now been increased from 2 years to 10 years. If you are employing children now, you face jail terms of almost up to 10 years. It was 2 years and they've moved it up. So it's a strong message about government stands on child labor, and I've just reproduced what the minister responsible for this bill said when the bill was tabled as the rationale behind it. It was to provide a more deterrent sanction given the backdrop of increasing trade sanctions on goods produced in child labor prone markets. So I think those of you who understand international trade laws, part of the issues that are topical when countries want to export and those that import, they look at how did you produce your maize, how did you produce your flowers, how did you produce your tobacco, for example. We realize that at your farm, all your laborers are children. A person comes with his family and then they are given a portion, and so if they know those things, that may affect the country itself's ability to sell to some of these markets. So government actually shows that, look, we're very serious about child labor. We don't want it, and anyone who is found wanting is there. So one looks at it and thinks, well, maybe it's a forced end, which is so much focused on trade. But at the end of the day, I mean, the question is who else, and what could be the reason why one justifies child labor? There isn't any justification. In the same way, I think that there is no justification for violence and harassment. Thank you, ladies and gentlemen. This is the end of the first segment.
Very well done indeed in terms of time. We move on to our next section, and it's really focusing on the duration, particulars, and termination of employment contract. This is a key aspect of the amendment, and just a reminder to keep taking notes for that discussion session after lunch. And to take us through this section is Tsitsi Mazikana. Just a brief background. Tsitsi graduated with a Bachelor of Laws Honours degree from the University of Zimbabwe in 2016. She's a managing partner of Lunga Mazikana Investments and Corporate Attorneys. Tsitsi is an exceptional labor lawyer who's risen in the professional ladder by winning cases on behalf of employers in the past 7.5 years. And I know there are a number of employers amongst us make that consideration for her practice. She is an innovative lawyer, experienced with developing case strategies. She's also an exceptional negotiator, deeply familiar with litigation and case management. Among other fields of law where she's gained a vast experience is labor law, and she was involved with that MCOS class action around the famous Zuva judgment in 2015, which exposed employers to a huge financial risk. She's satisfactorily managed to represent employers in all matters and has come up with almost a 95% success rate. Apart from handling labor briefs, Tsitsi handles most general legal work in the areas of conveyancing, notarial work, debt collection, civil litigation, family law, and legal drafting. A round of applause for her, please, as she comes through.
Well, thank you very much. That was a powerful resume, which I also didn't know about. Okay. So my presentation is mainly covering a few sections, and it is split into two categories. The first category dealing with Section 12 of the Labour Act as amended. So unlike my co-counsel, I will refer to the sections as they are in the Amendment Act, because I believe that is the one that you are looking at, and that is the one that we want to attack mainly. So this segment is going to deal with Section 12, which has been amended, which deals with the particulars, duration, particulars, and termination of employment contract. So you'll notice that Section 12 of the Labour Act was only amended insofar as Section 4A, which is the termination of contract, is concerned. I will not dwell much on the unaffected areas of the provision, because those ones we all know, isn't it? So you realize that since the Zuva judgment, there has been an outcry from the employees, where there was an influx of employees being sacked from employment on notice, where employers wantonly terminated contracts of employment without any consideration to the duration and any other circumstances of the employees. So I must say that our legislators were very emotional from the Zuva judgment. It was pressure or something, I don't know. But there was a hashed amendment to the previous Labour Act in the Labour Amendment Act of 2015, where the legislators sought to introduce the 4 ways that employers could terminate the contracts of employment on notice. Again, I noticed that there has not been much consultations on this particular aspect, as you realize that the Amendment Act of 2023 is it's coming from one extreme to the other extreme, where employers can barely terminate a contract of employment on notice. You realize that the provision that is in the Amendment Act of 2023 only provides that an employee can terminate their contract of employment with the employer either on resignation or retirement. And on the part of the employer, there are only 2 ways that a contract of employment can be terminated. This is by mutual agreement in writing. And for breach of an express or implied term of contract, which is through disciplinary hearing. In terminating for breach of an express or implied term of contract, this is where an employer is mandated to carry out due inquiry. There has to be the right to natural justice. You have to carry out a due inquiry for the breach, and this breach is for an applicable employment code or in any other manner agreed in advance by the employer and employee consent. We are not going to have employers who just wake up and say, oh, you are supposed to come to work at 7:30 just because you decide to terminate a contract of employment, but there was no prior agreement with the employee that your work starts at 7:30. We have a lot of employers who have relaxed their conditions of services. You realize that, I don't know, maybe it's the economic setup where employers are being reluctant to enforce their contracts with their employees. But you realize that there are certain terms of employment contracts which are not negotiated prior to engagement by the employer and the employee. And when the employer has decided that they don't want the employee anymore, they just wake up and say, oh, in terms of your contract of employment, you were supposed to report to so and so, and you didn't do so. In terms of your contract of employment, you were supposed to go for lunch for only 30 minutes, but you exceeded by 5 minutes, so we are terminating your contract of employment. So the most important aspect of this provision is that you have to have a code of conduct or an agreement with an employee prior to engagement, so that when you want to terminate the contract of employment in terms of Section 12, it has to follow that an employee is actually aware of the condition that they have breached. The downside of this amendment is that there will be a high rise of disciplinary proceedings for the most petty offenses that the employees will commit. The amendment has restricted the relationship between the employer and the employee to an extent that once you have hired me as an employee, I'm here to stay. I'm not going anywhere, and there's no termination of that contract of employment on notice. It's more like cultism, isn't it? So it restricts the relationships between the employer and the employee. However, what I'm noticing is that this amendment, there has been a complaint from a lot of employers where they say that we have employees who just say, I'm leaving employment with immediate effect. I'm resigning with immediate effect. And the employers have always been complaining that you leave my office, you leave my work hanging. I have something important that I want you to attend to, but you have not given me an option to find a replacement. So there's been nothing that has been put in place to cover the employers in that aspect. In as much as the legislators are trying so hard to protect the employees, I'm not seeing anything that protects the employers in this provision. So the provision will be welcomed by the employees, but it's a short-lived joy because we are going to have more disciplinary proceedings than ever, as employers hold that it is better to terminate a contract and deal with damages than to retain an employee that I no longer want in my employment. So I think there's still more that needs to happen in terms of Section 12, in the sense that employers need to be allowed to terminate contracts of employment on notice, as this is a free and voluntary engagement between employers and employees. So with respect to the amendment to section 12, this is the end of my short and precise presentation. I will take it up in the next segment. Thank you so much.
Thank you. I think Tsitsi deserves a huge round of applause for being precise. And thank you so much for that. And it's so interesting, the implications on of those amendments on the contracts, that relationship, that contractual relationship between the employer and the employee, the complexities thereof. And it looks like there is going to be discussion around this even in the afternoon. So I'd like to call upon Advocate Magogo again. And this time he's looking at the retrenchment and compensation issues, non-payment of retrenchment packages, and so on. Another round of applause for him.
This segment, if you look at your program, deals with retrenchment, and it also deals with the new section 12C that has been introduced, which should bring a bit of gnashing of teeth for a couple of employers, as we shall see. So, by way of introduction, you understand that retrenchment has been a topical issue of late. I think this is a second consecutive amendment where you have the legislature or the lawmaker not amending one section, but the whole section 12C. It has just been thrown out and a new one brought in. And so with each amendment, I'm going to speak to these comparing with what existed before 2015, what existed post-2015, which we are getting out of now, and what we have. You will notice that there's a departure, and part of it is an attempt to perfect some of the problems that we saw with the 2015 amendment. You would agree with us that there's been a lot of litigation on this area and a lot of problems as to what exactly did the legislature mean. So I have broken this down into a few segments, and I think it will help us to get an understanding of this. So the very first, so what's new? I think that's where we start. The very first point to note there is you'll notice that it's a longish section, and Mr. Norway and team, I think go and tell them, those who draft these things. I don't know why you trouble people like that. We have a paragraph which has got 12 lines. It's one sentence. It's just explaining things, and it makes life difficult for so many. So I've just tried to break it down in the simplest of terms so that you understand what is in all those long paragraphs. I know they want us lawyers to survive in interpreting, but they must also make it a bit simple so that it's a win-win situation for all. Okay, so the first difference that you find between this current regime and the old one is that there's now a difference between what is referred to as a minimum retrenchment package and what is referred to as an agreed retrenchment package. There's also another creature which you find somewhere which is called an enhanced retrenchment package, even though it's not defined. But what is problematic, I start with the problems here, with this definition is that we know what an agreed retrenchment package is. It's a package that comes after an employer and employee agree to say, okay, yeah, this is the minimum, but we can pay more. And if we agree, that is an agreed retrenchment package. But who has noted that there is no definition of a minimum retrenchment package in the Act? Section 12C2 of the 2015 amendment told us that unless better terms have been agreed, a minimum retrenchment package of 2 weeks salary, whatever, it was there. Now, we have removed that, and we've only retained the word minimum retrenchment package. Now, if you ask me, how much is the minimum retrenchment package? It's not there. in the Act, Mr. Norway. Aimo, Act. So I don't know why they never saw that. It's not there. So as to what is the minimum retrenchment package, we should be lower than an agreed retrenchment package. It's not there. If anyone saw it somewhere, please, let's talk about it in plenary. I looked for it. In fact, there was a time when I made a presentation somewhere, should have been in Victoria Falls, I think, and I was asked to comment on the amendment bill and to give insights as to areas where I thought they needed amendment. And I brought that paper, if anyone doubts me, because I remember very well mentioning that issue to say, I don't see where a minimum retrenchment package is defined. Can this be rectified? I remember sending that to some people, some of whom are here, whose names I won't mention. I don't know whether you send it through, but so it's not there. So there's a distinction between a minimum retrenchment package and an enhanced retrenchment and an agreed retrenchment package, but there is no definition of a minimum. I think there was it was taken for granted that people now know that minimum retrenchment package is 2 weeks salary for every accept, but without a statute that says so, you can't say. So I think that's an issue, in my view, which will quickly require amendment, because it's a clear drafting error. But there is that distinction. So you can see that the intention is to distinguish between a minimum and agreed retrenchment package. One of the other problems that we used to have in the 2015 amendment was that there was a debate as to whether or not, before an employer issues a notice to retrench, they must engage the employees. I remember dealing with a case, I had Mr. Gwisai on the other end, and he was arguing to say, look, there must be implicit in that provision, unless better terms are agreed, is the need for there to be an agreement, to be a discussion. And we were saying, look, it's not anyway. It simply says if you don't want to pay more, if there's not been an agreement, then let's go to the minimum. And my argument was that, look, if an employer knows that they cannot afford anything more than the minimum, why should they waste time negotiating? And I think you have different viewpoints, particularly from Labour Court judges on that. Now, in this particular amendment, please get me right, it does not say that you must, as a matter of necessity, engage before you give notice. Get that right. But I interpret particularly subsection 3 of section 12C as suggesting the need for compulsory engagement before you issue a notice. Why do I say so? Because if we look firstly in the definition of minimum and agreed, it means minimum is what is already said. Agreed is something that we will talk about and agree on. Now, subsection 3 then says you give notice of intention to retrench in the absence of an agreed package. So I suppose that because we have not agreed on something, we therefore go to the minimum. I read that to mean that the intention is that, look, try and talk before you give notice. Why? Because if you don't talk, as you will see later, the employees feel that you can pay more. They will petition the board or council to have you explain why you can't pay more. So I think it's something, if you don't engage the employees before and you just say, I'm paying the minimum, you run the risk of going before the retrenchment board or the employment council to explain that why shouldn't you pay. So I read those provisions, the one that says, well, agree, or if you fail to agree, then go to the minimum package, and the one that allows employees to approach the retrenchment board to say, the employer is able to pay, is kind of like suggesting that it is the ideal thing for the employer to try and engage people before they retrench. So that's the main distinction that exists between what was there and what is now. Now, let's look at the process quite quickly. So the 14 days notice should be given to the Workers' Council or to the NEC or to the, where there's no Workers' Council, to the NEC, and, get that right, to the retrenchment board. So whether you've given it to the NEC, whether you've given it to the to the Works Council, but the retrenchment board is not optional. You have to notify the retrenchment board. Mr. Norway, at some point when we were discussing the 2015 amendment, the understanding was that the amendment retrenched the retrenchment board. it took it away. Now it has reinstated it, this one. So the retrenchment board is back, and it seriously is back at work. And I tell you, it is also an area which needs serious capacitation because of the obligations that the Act places on them. But the retrenchment board is back, ladies and gentlemen, and back seriously in business. So negotiations for a better package can still be held after the notice. So remember, I said there's no provision that says do it before. But this kind of clauses that says even after you've given notice, you can still hold negotiations. Means that if you know you can negotiate before, then just do it, and so that you don't lengthen the process. Because if there are negotiations that happen after the notice, then that may also affect the process as it is. And so when the retrenchment board has been notified, it issues now what is referred to as a notification certificate, which I've just put in for short, the NC, within 15 days, if there is a minimum retrenchment package to be paid, or within 14 days if there is an agreed package. So get that right. 15 applies for where there is a minimum, where you are paying the minimum package. 14 applies where it is for the agreed retrenchment package. That is in subsection 5. Then the notification certificate itself by the board. So when the board receives that notification to say we are retrenching these people, etc., etc., it has to issue this certificate, and the certificate, in terms of law, should be posted on a notice board. I think at the retrenchment board office or wherever, they should put it on their board for 7 days. Or virtually. I don't know whether they have a website or something. It should also be posted virtually. It's a requirement of the statute, so that it should not be a secret that someone is being retrenched. And these are all statutory provisions that are couched in peremptory terms. And I think it's also issues that the board should have in mind. Then where there's a dispute as to whether or not that notice has been posted, an affidavit by the employer that it complied with the notification requirements suffices in the absence of that certificate. So, say for example, the employer notifies the board, and then the board does not issue the certificate, or the certificate is not posted, and the employee comes and says, well, the retrenchment is a nullity because the statute says you shall post a notice. The statute then says, no, if an employer does an affidavit and says, yeah, well, we submitted to the board, then that should be taken prima facie as evidence that compliance was done. Obviously, when we say prima facie, the employees can always dispute that. Let's move on to the next slide. What happens? So that's a simple process, ladies and gentlemen. You according to me, you engage, you give notice to the council or to the Works Council or to the National Employment Council. You notify the retrenchment board. The retrenchment board gives you a notification certificate. Post that notification certificate, and the obligations by the employer would have been done there. Now, what happens if the employer defaults? I think it's an issue that we need to talk about. Subsections 5 to 8 of section 12C. So there are two options. There is a civil option and there is a criminal option. So unlike the previous section 12C, the previous section 12C, if my memory serves me well, did not have a provision for criminalizing anything. Now this one criminalizes a failure by the employer. So there's a criminal option and a civil option. In the civil option, there are two stages again. So there's a civil process that you take to the retrenchment board and one that you take to the labor court. So let's look at the civil. Let's look at the criminal process quickly and get on with it. I see my brother, Mr. Nema, is there. It's allowed to acknowledge people that you know. I acknowledge you, my brother. Anyway, so firstly, the failure to notify the retrenchment board in terms of subsection 5 is a crime, punishable again by a level 12 fine or imprisonment. Again, our draft person then forgot to tell us how much imprisonment is there. I don't know if anyone's copy has it, but it simply says imprisonment, the one that I read. So this imprisonment, however, is whenever we talk of the employer, we're talking of the board of directors. Okay, so if you're on the board and you fail to comply, and the employees choose to take you to court, then you are in trouble. You know you are in trouble. And it won't be you, it's the HR manager who should be doing it, but it's not the HR manager whom the law wants at court, it's you. So you need also to ensure that that is done. But level 12 fine, although they don't specify the period for imprisonment, remember when I was talking about child labor, when I was talking about sexual harassment, I said they've elevated those crimes from level 7 to level 12. From 2 years imprisonment to 10 years. So here is the same level 12. They didn't specify imprisonment. My guess, I'm not a prophet, should be that maybe they also wanted the same 10 years. If you look at the level of fine that they've put, level 12 and 10 years, they go hand in hand in the previous amendments. So that could be showing you the seriousness with which the legislature treats this issue, and you mustn't play around with it. So that's the first thing. If you don't notify the board and you don't get that certificate, you are in trouble in the criminal sense. Then secondly, in the civil route, if the employer does not notify the retrenchment board, the full amount of the minimum retrenchment package vests in the affected employees. So the full amount is now due. The employees are now entitled to it as it is. And so the package now has to be paid within 21 days of the retrenchment date, or the employees can seek enforcement at the retrenchment board, where they get a certificate which they then take to the labor court for confirmation. So if the employer does not notify the board, the employees are suddenly entitled to the amount that you have agreed, or the minimum retrenchment package. So imagine you have agreed with your employees, or you are paying the minimum retrenchment package. You think everything is done. We have agreed. Why should we notify the board? The law is clear that you should, and if you fail, there is a criminal sanction to it or a civil sanction, which you must be aware of. Thirdly, next slide. Yes, thirdly, employees can petition the retrenchment board on affidavit if the employer delays or fails to pay the agreed or minimum package. The employer is afforded a chance to make representations, and the retrenchment board, if it has looked at the representations and it considers that the employer is in default unreasonably or has actually delayed unreasonably, it issues what is referred to as a non-compliance certificate. What I say NCC there, subsection 6. So if the employees feel that you are delaying or you have failed to pay, they approach the retrenchment board again. This is another civil route, and the retrenchment board affords the employer a chance to make representations in writing and even orally to hear the employer to say why, what's happening. And then if at the end of those representations it considers, there's no justification, it issues what is referred to as a non-compliance certificate. It is this non-compliance certificate which the employees then take in terms of subsection 7 to the labor court for confirmation. Now, once the non-compliance certificate is issued, it's binding on both parties and should be complied with. So once the retrenchment board has given us a non-compliance certificate, employer is supposed to pay this much, you didn't pay, we think that there's no justification, or you delayed, there's no justification. Once a non-compliance certificate is issued, employer should comply there and then. But if you fail to comply, then the employees have to approach the labor court for an enforcement order based on that certificate. So what you must understand is that should be subsection 7. It treats the non-compliance certificate as a liquid document. Those of you who have litigated maybe in the High Court, where you are suing a person on the basis of an acknowledgement of debt, or in the basis of a claim which is easily ascertainable, no need for calculators, no need for evidence. It's there, the document speaks for itself. You owe me $20. It's written. So that is the same status that the non-compliance certificate is given by the statute. So it's a liquid document. So the importance of that status is that when we go to the labor court and the employee has taken it to remember, the moment the retrenchment board issues it, it is binding. You're supposed to comply. But if you fail to comply, the employee takes it to the labor court. I want you to understand the nature of proceedings that should happen in the labor court. If it's a liquid document, the employee simply goes, presents it. This is it. It comes from the Ministry of from the retrenchment board. Everything, if it's a certificate or whatever, is there. Once it is presented, as an employer, you can't come there and start saying, no, but the amount is too much, or all those. No other defenses could be accepted. It's more like a routine process of just having it get into an order of court. Otherwise, there's really not much room for you to dispute whatever in that certificate. So the process is actually given to you when you approach the retrenchment board, when you make representations before the retrenchment board. Once the NCC is issued, then it's as good as done. So the labor court order then is submitted for registration to the High Court or the Magistrate Court, as the case may be, for enforcement purposes. This is what I consider to still be our elephant in the room in the Labor Act. I don't understand, and I still need an explanation. Maybe I'm Norway who assist. Why we don't trust the Labor Court? Why we don't have faith in the Labor Court judges? We have seasoned labor persons there. We have been making decisions in the labor field for a long time. But we don't trust them so much such that when they make a decision, we want that decision submitted to a magistrate. Can you imagine? For a magistrate to stamp it so that it becomes an order of court. To a High Court judge, maybe you can understand the High Court judges say that they are a little higher than Labor Court judges. But in terms of specialization, the Labor Court judges should be experts in labor law. Okay, but the statute still, I thought this is one of the amendments that would have come with this one, to say, why can't we capacitate our Labor Court with its own messenger of court or sheriff, so that when a judgment is registered or when a judgment is issued which says pay XYZ amount to B Magogo, then I should just go to the messenger. I don't need to go to the High Court again. So imagine, you have gone before the Retrenchment Board. There have been proceedings in terms of which the employer has made representations. The Retrenchment Board has made a decision that you're supposed to be paid your $10. And the employer does not pay it. You go to the Labor Court for it to be recognized as a judgment or to be registered so that you get an enforcement order. Now you think you are done. You are not done. You take it to the High Court again, or to the Magistrate Court, depending. So you know that these courts have monetary jurisdictional limits. The High Court would have more, the Labor Court, the Magistrate Court has lower. So depending on how much you have been awarded, you go to the court that has jurisdiction. To just go there, and mind you, the process that happens at registration in the High Court or the Labor Court, on the Magistrate Court, is again clerical. The judges have done, the High Court judges have done several judgments to say, you can't come here and oppose an application for registration if a person has shown that this is a judgment of the Labor Court, issued by the Labor Court properly. It says what it says. The process there is just to register, unless one can show that maybe the judgment conflicts with public policy, among other very serious exceptions. So it's a clerical process. Why are we going to the High Court? Why are we going to the Labor Court? It's an issue that every time I hear that there is an amendment bill of the Labor Act, I look for, to say, have they eventually now given the Labor Court the status that I think it deserves? That has not happened. So it still remains there. So you take it to the... So it's a process. Imagine, from your employer to the Retrenchment Board, from the Retrenchment Board to the Labor Court, from the Labor Court then to the High Court. And from the High Court, if someone is not happy, appeal to the Supreme Court. Rather than maybe coming just from the Labor Court, if a person is not happy, then they take you to the Supreme Court. You take the shortest route to the Supreme Court, but you have to go via Mapondera building. So that is a problem which I still think has to be dealt with in the Labor Act. Now, what if the employer alleges lack of capacity to pay? I think you understand. So somebody was saying, I don't know, maybe it's Kumbi or Mr. Zio was saying, retrenchment process, it has been... I don't know the word that you used. Is it shortened or what? I think it has not been shortened. I think that it has actually become, in terms of the time, I acknowledge the rage. I see. Were you there when we started, ma'am? Yes. Sorry. I had not seen. Thank you so much for being there. I think so. I'm no longer addressing Mr. Norway. I'll now bring it to you, because these are some of the things that are there. So what if an employer alleges lack of capacity? It was there, it is there, slightly different. Within 14 days of retrenchment, pay, so the employer is now allowed to pay not less than 25% of the minimum package. Maybe one thing that I must emphasize before we conclude in the current regime is now that all these issues to do with lack of capacity, all these issues to do with perhaps there is a problem with the employer and we want the retrenchment board to be involved, can now be done post-retrenchment. So they may not store retrenchment. If an employee feels that the employer has to pay more, and or the employer feels that they have to pay less, they can actually pay 25% of the minimum retrenchment package according to this provision. And the retrenchment is done, you are retrenched. But then the discussion as to whether they should be allowed to pay the other 75% can happen, but you are already retrenched. That is why if you look at the timelines actually says when after retrenchment or 14 days of retrenchment, it means that the retrenchment would actually have happened already. So the first thing is, if an employer alleges incapacity to pay the minimum package, you can't obviously allege incapacity to pay an agreed package. Within 14 days of retrenchment, so the employer, I was saying, if you have agreed to a package which is more than the minimum retrenchment package, we don't expect you to go and say, I can't pay it. Okay? But if you have stuck to the minimum retrenchment package and you still feel that I can't pay the package, the law says at least pay 25% so that you give these employees and they go with something. But you then make an application to your NEC, in the case of an NEC, or to the retrenchment board for exemption. I mean, the exemption applications, we've been doing them since time immemorial. You provide all the necessary, albeit reasonable evidence, which evidence your financial incapacity. So you are alleging that you are financially incapable of paying. So you must give as much evidence as possible to justify your allegation. You save the employees naturally with the application because they would really want to oppose that, and they need the right to be heard. The Employment Council, or I think employment councils normally have specialist committees, exemption committees that deal with this, or some they sit as a full council, or the retrenchment board considers the exemption application within 30 days after hearing both parties. So if it hears you, it has 30 days, rather it has 30 days from the date of the application, let's get that correct. After hearing the parties, it's just emphasizing that a decision has to come after parties have been heard. But the 30 days are not starting from the date of the hearing. They are starting from the date when the notification was received. The determination is then made after the parties have been heard, like I said, and it is appealable to the Labour Court within 21 days of its pronouncement. I think that was also one of the problems that we had in the previous dispensation. When the Retrenchment Board has made its decision, there was no provision that specifically then gave a right of appeal to the Labour Court. So 21 days, you do that. Then if you fail, remember the previous one said, if you fail to respond to a application within 14 days, then it is taken as having been granted. There is nothing like that in the current amendment. Now, the failure to decide the application within 30 days from that date of receipt, the aggrieved party again has a right of appeal to the Labour Court within 21 days from the date when the 30 days expire. So let's break it down. You apply today. When 30 days lapse, this is the time within which the application for exemption is supposed to be heard and determined. If it is not determined, you have 21 days from the 31st day going forward, okay, to approach the Labour Court and challenge the failure to decide the application, and the Labour Court deals with the matter as it is. Can employee challenge the decision to pay the minimum package? So we said if the employer says, I can't pay, the employer can go and apply. But the statute also now says if the employee feels that the employer who has said, I am paying, I only afford a minimum package, can actually afford more, that employee is now given a chance to also approach the Labour Court and ask that the the Retrenchment Board or the Employment Council to ask that the employer be ordered to pay what is now referred to as an enhanced retrenchment package, which is why, if I take you back to where I started, I said, it is foolhardy for an employer to just issue a notice of intention to retrench without engaging your employees. Because if you don't do that, the statute allows them. If you say, I can only afford the minimum retrenchment package, they will allow you to do it. But you still have litigation afterwards. It's better you sit with them, justify to them, make sure that they see the kind of dire situation that you are in. And so that when the retrenchment happens, there is no litigation that comes after it. So you may think that, well, there's no provision that specifically says we should engage before, therefore I'm not engaging. Trust me, you will have this litigation coming post your decision to retrench. And I think that's something that that you may need to think about. So within 60 days of the issuance of the notification certificate, remember we said if the employer has agreed or has said we're paying the minimum retrenchment package, they have an obligation to give notice to the retrenchment board, and they get the notification certificate. Now this clause now says within 60 days of issuance of a notification certificate, the employees can petition the retrenchment board alleging the employer's capacity to pay the enhanced retrenchment package. I say or by extension NEC because the statute in subsection 13 does not say retrenchment board or NEC. But if you then go to section 14, which talks about how the application is dealt with, then the retrenchment board and the NEC are there, which means that this could have just been an innocent omission rather, but the application can be made to the board where there's no NEC, but where there's an NEC, it goes to the NEC. So you allege the employer's capacity to pay an enhanced package. So it's now different. If we had agreed, we would have called it an agreed retrenchment package. Now we are going to the retrenchment board, and the retrenchment board is going to tell us whether or not it's the employer is able. If the retrenchment board says it's able, the package that comes out of it is called the enhanced retrenchment package. The employees give particulars of any proof of capacity to pay. Remember, the employees are not giving proof because sometimes they don't have it. If they ask you, give us your financials so that we send them to the retrenchment board, you say, what financials? Confidential documents don't give you. So they will say, no, we know that this year, so the law says give particulars of any proof. We know that last year they declared a dividend. Here is a newspaper. Or we know that last year production was at 90% or 100%, something like that. That just throws it in there for the employer to come and disprove. So the obligation for the employees is to provide particulars of any proof, not necessarily the actual proof, because sometimes the employees may not have it. If they have it, then they should give it there. So the NEC or the retrenchment board receives the representations from the employer. Obviously, the employees have to save the employer. The employer then is given a chance to give a response, and the response of the employer is required in affidavit form. Because this is evidence, and so they want you to be as truthful as you can, and then you also attach audited financial statements. So if an employee alleges that you are able to pay more, and you say we are not able to pay more, but you don't have audited financial statements, the law says you should attach them. So if you don't attach them, then you may fail to rebut the presumption that you are actually able to pay. So they think that audited financial statements are a statement by somebody else outside that you are not able to pay. That you and your manager sit down and agree to come with your management accounts or statement of income and expenditure, that's not enough. The statute requires audited financial statements. So if you come without audited financial statements, you would not have complied with the statute, and you may not be able then to rebut the presumption. The determination then is made. So the consideration is made, the employees allege this, the employer's evidence is this, surely the employer does not afford, then the matter ends there. If the employer affords, then the retrenchment board gives a decision and gives an enhanced retrenchment package. That determination again should be made within 30 days of receipt of the application. Just like the exemption application, you appeal within 21 days. If a decision is not made within 30 days, you again can appeal to the labor court. Failure to comply with the decision of the NEC or the retrenchment board in this regard is a crime of contempt of court, and the statute actually refers to section 182 of the Criminal Law Procedure and Reform Act, which is punishable. I looked it up. It's punishable by a level 6 fine or imprisonment for 1 year or both. So if an employee alleges that you are able to pay, the retrenchment board confirms that you are able to pay, and you fail to pay, the employee can choose not to go to the labor court, but go to the criminal court, and you are in trouble there. Now, there's something new, ladies and gentlemen, that has come in the Act, which was not there before. So, if to try and evade having to pay a retrenchment package, so you know that you need to retrench in the next 6 months, and then you start ordering your affairs in such a way that your company becomes poorer, your company becomes less viable, so that by the time you are retrenching the employees, you are telling them, look, we are in trouble here. Okay, so you do that through fraudulent or reckless conduct on grossly negligent conduct. So get the causes. It could either be fraud, like the scenario that I gave. You're actually planning it to say, we want to make sure that these people go with nothing. We have people here that have been serving us for 30 years. Where do we get the money to pay them? So let's run it down. So you actually plan a very shrewd scheme. Or it could be out of recklessness. You just running your company with no consideration of whether you are going to remain afloat or not. Or it could be gross negligence. So you could be actually doing, a grossly negligent person may actually be doing their best, but in such a negligent way that, so it's either intentional or not necessarily intentional. In either way, if what you do can be interpreted as running the business in a manner that render the employer unable to pay the package, you open yourself up for employees to take you up to say, look, we are only getting a minimum package, or we are only getting 25% of the minimum package because these people in the 6 months, in the 1 year leading to the date of retrenchment, have been running this company in a fraudulent way, in a reckless way, or in a grossly negligent manner, which has resulted in this kind of financial status that they are in. And if that is proven, it has its own consequences. So the rationale of this clause, when I read the bill, it says is to ensure employees do. So some of these things also, as HR practitioners, you may take interest. If you look at the HB 14, the bill itself, it also outlines at the beginning the reason why Parliament was putting these laws. I think it can also be very helpful for you to get an understanding of this. So in the bill, they indicated that it is to ensure that employees do not evade having to pay retrenchment packages. Employers rather do not have to evade having to pay retrenchment packages by fraudulent or reckless conduct in their business in a manner that render the employer unable to pay the package. So what happens if an employer who alleges financial incapacity in those section 12C9 proceedings? Remember, when you apply for exemption, you are alleging incapacity. You are asked by the retrenchment board or the NEC in those proceedings to respond to allegations in the affidavit form. If it emerges that you deliberately stripped or downgraded assets in contemplation of retirement, started selling assets to people and started transferring them to people in a way that contemplates retrenchment. You carried on your business recklessly, fraudulently, or negligently. I think those of you who are familiar to liquidation proceedings, those of you who are familiar to divorce proceedings, you can't fail to find one. You have to find one in between those two. So for liquidation, there's a similar provision where the liquidator can be allowed to follow after the directors of the company if it is shown on papers that, look, the manner in which these people were running the company contributed to it now being in liquidation. They can be followed after. And some of these dispositions, if you start disposing assets in contemplation of litigation, it can come after you. Again, the same applies for divorce. You now know that the relationship is not working. You just wake up together. You're not happily married as I am, and you know that it's not working. You know, it's Kumbi who said it, guys. So you now start selling assets. Suddenly, your brother that you never loved, you are selling to them your house, and they are paying 10,000 for a house which is in Marlborough or somewhere there. And then by the time the divorce order or summons is issued, we realize that this guy does not have anything, or this lady does not have anything. There are people who do that. The law will follow it to say it's either you sold when divorce litigation was pending, or when parties were contemplating divorce. Okay, so that's the same principle that is now being also imported here. Okay, so we're not talking about divorce. Please, I'm not giving you any advice on divorce. But I'm saying that's the same principle that has been imported here to say, because you are parting ways with an employee or with employees, they are losing a source of livelihood. So give them the best starting point as you can. So if you take steps to ensure that you reduce it, and you take steps to ensure that those people who are joining the unemployment queue in the country are also very poor, then you are giving us problems. So if the employees can be able to prove that that happened, then they are allowed to approach. So let's assume you have approached the Retrenchment Board or the National Employment Council and you are applying for exemption. The statute then says if it emerges in those deliberations that in fact your status is self-imposed, then and it's seen that you have deliberately stripped or downgraded assets, or you are carrying business recklessly or fraudulently, then you are in trouble. The Retrenchment Board or the NEC can issue a provisional order after hearing you to say we find as a matter of fact that you downgraded your assets or you stripped assets, or we find as a matter of fact that you were fraudulently or recklessly running your business. Therefore, you are supposed to pay the whole package. Because remember, it will be an application for you to say, I am unable to pay the minimum package. But when they see that, but you are where you are because of your own problems, then an order would be made. So the Retrenchment Board or the NEC issues just a provisional order, okay, which is subject to confirmation at the Labour Court. So the employees in question, who will be the beneficiaries, can then approach the Labour Court seeking confirmation of that, at which stage in the Labour Court you are also given a chance again to argue that that order should not be confirmed. Okay, so the order, you have a chance to be heard. Either the order can be discharged or confirmed. Then when it has happened and the Labour Court has issued a judgment, again, you are going to the magistrate court, you look for your way to the magistrate court or for your way to the High Court for registration, just like any other orders. Okay, so what does the Labour Court issue? The Labour Court can issue a general declaration confirming the provisional order and or a specific declaration imputing liability on the specific owner or director of the employer who is liable, including anyone who was a knowing party to the carrying on of the business. So remember, in that earlier segment, we talked about directors. Now, it focuses on the Labour Court can issue an order to say, okay, we realize that the person who was fraudulently or recklessly running the big business or in a grossly negligent manner is so and so. Okay. But we also know that this HR manager was aware, this financial manager was aware, because the statute says anyone who was a knowing part, so it was you who was sent, go and sell this, go and transfer this. So anyone there is also in trouble. So the Labour Court can impute that liability. But remember, all this, you cannot get such an order against you without being heard. So manager or someone, they'll obviously be called and then they have to be involved. So it's food for thought. I think it's a serious provision that we must think of very well. I think the idea, if I look at it ultimately, the intention is to ensure that the retrenchment of employees should be done in a way that at least gives them something to go and ensure that they don't retire in penalty. Okay, so I move quickly to the next segment. I think I can do this in the next 4 minutes because there's very little that is there. The third segment, ladies and gentlemen, starts at Section 18. Section 18 of the Labour Act is that one which now aligns with Section 65, subsection 7 of the Constitution. I think if Mr. Mcheche was here, he would recall there was an application which was made sometime, I think after the amendment, where they were seeking an order that the statute, Section 18 as it was, be declared to be unconstitutional because it required a person to have worked for a certain period before they could qualify to go on maternity, and it restricted the number of periods within which a person could actually go on maternity leave. Okay, if it was my wife, she has had 3 babies now, she couldn't go for the 4th one with the same employer. Now we can have as many as we want, as we are planning, because the statute now says you can go, and no employer should say, but don't you think that it's now too much? No, why should you do that? Jacob at 12, who are we to end at 3? So the statute now allows you to give birth as much as you want. So if you had I know there are some people who then say when they realize that the number 3 is, we have reached number 3 and they are afraid that they may accidentally fall pregnant, they then go and get procedures to make sure that it never happens again. If you can reverse that, please go. Now it's free for all. Go ahead and give birth. We want more and more people. So the simplicity of that amendment is simply that we've now aligned our constitution. There's no qualifying period. You can get into an interview today, get a job next week, and then apply for maternity leave next month. If the interviewers and interviewers are not supposed to discriminate on the basis that you are carrying something. Okay, so if you somehow manage to sneak in, and then you before you are done with your, what do you call it, probation, you are applying for it's allowed. And like I said, there's no cap. That is what is in our constitution. This has nothing to do with anyone. We all agree that is what we want. I think it's noble. I think that is national service, which the ladies do, and I think they should be allowed to do it as much as they can. In fact, having a person volunteering to have 4, 5, 6, 7, with the news that we hear of how difficult and how painful it is, I think it's a gallant act which should not be punished at the workplace. Okay, we should allow them. Section 25 is the next section. Very controversial in my submission, and I say this, Deputy Director Maripo. It says that it is now removing the minister's powers to veto a CBA negotiated by Workers' Committee. I think there was that provision that says if it is unfair or inconsistent with the act or whatever, they said, look, remove that. There should be people who are able to negotiate that on their own now. But there's a new provision which makes the minister responsible for any state entity or body corporation or entity to be a party on equal footing with such employer and is therefore a party to the negotiation of a CBA. Let's understand this provision, ladies and gentlemen. I understand it when we deal with Section 82 because it is bargaining at National Employment Council level. But what this provision says is that if, for instance, I had Zinwa here, isn't it? Yes. So Zinwa or Zimra, ZESA, these are state entities. Yeah, ZESA would be a deal for this sector, isn't it? ZESA, it means that at Works Council level, where they are, at Workers' Committee level and Works Council level, where they are negotiating for a workplace bargaining agreement. You know our statute allows that, right, in Section 25. The minister responsible for that state entity is a party on equal footing with such employer and is a party to the negotiation of a CBA. So I know the ministers won't come, they will send somebody else, but you ask yourself, okay, so the entity itself, it's ZESA for instance, is there, it is represented, then the minister is also a party, is not a party in place of the entity, is a party on equal footing with the entity, which in a way means that you actually have two representatives for the same entity. I think it's an issue that we must discuss at length when we go for the plenary. I think some may justify to us, particularly those from the ministry, perhaps the wisdom in it. I looked far and wide, up and down. I didn't see it. Paid educational leave, Section 25A. The employers are now required to consult works councils on any proposals relating to its policy stipulation on paid educational leave. So I think on issues, Section 25A outlines the issues that must be deliberated at works council level before you just put in a policy. So there are a number of issues that are there. One of the issues that have now been added is that the issue to do with paid educational leave, and I think the bill gives us the rationale for it to say, as Zimbabwe ratified the ILO Convention 140 on paid educational leave, and for that reason it requires, because it encourages employees to further their studies, but there must be a policy at the employer's level which allows that to be done and the ways in which it can be done. So you can't just wake up and say, this is our policy. You need to take it to the Works Council. I think it's a progressive amendment. I just took 2 minutes out of the time allocated. I think they should clap hands for me. Time-wise, thank you.
Thank you very much. Packed morning session as we had forewarned, but very rich in terms of content. Another big round of applause to our facilitators. Thank you so much. So we're breaking.
We live in a world of great uncertainties, and whether we like it or not, unexpected situations that can compromise both our health and that of our loved ones can happen. The question is, are we prepared? With EMF Medical Society, the answer to that question is a resounding yes. At EMF, we aim to ease the financial burden that medical bills can place on you by offering reliable, comprehensive healthcare cover at affordable rates. Our medical aid packages are specially formulated to cater for the diverse needs of Zimbabweans from all walks of life in both the formal and informal sector. Our healthcare benefits include dentistry, pathology, access to specialist services, optical care, chronic and acute medication, among others. So make the smart choice. Join EMF Medical Aid Society today, because nothing is more important than your health.
It's actually allowed for you to employ a person and say you are only working for 4 hours. You are only working for an hour in a day. It's allowed, okay? But when you do that, the statute does not allow you to then say, if you work for me from 8 to 10 a.m., then from 11 a.m. to 4 a.m., you can't be working for someone else. That's what subparagraph A says. Your terms should not prohibit the employee from being employed by another employer or on his or her own account during the hours when he or she is not working for you. So you want Kumbirai to work for you for 2 hours, but you also don't want Kumbirai to work for Magogo for the other remainder of the hours. The statute says you can't do that. So if you decide to hire me, so the idea is that if you want me for yourself, then I'm available. But if you want me for a certain period, then allow some people to also have a piece of me. Then B says, if the effect of such a contract is that in any consecutive period of 2 months, the employee earns less than the minimum remuneration or wage fixed in a collective bargaining agreement as the minimum rate of remuneration or minimum wage for the undertaking. So let's wait there a little bit. So we enter into an hourly contract where, giving the example that we gave, a person is working for you for 2 hours per day and you're paying them hourly. Okay, if you aggregate the 2-hour wage per day multiplied by the number of days in a month, and in a period of 2 months, the amount that the employee gets is such that it is less than the minimum remuneration or wage fixed in a CBA, then that kind of a contract is not allowed. So if in 2 months of working for you in hourly contracts, I can't get enough money to get a salary for 1 month in terms of the CBA, then that contract is not allowed. I don't know if I'm clarifying it. So whatever contract, so the idea is that the number of hours, that is the rationale, the number of hours that you are engaging a person should be such that if they work for you for 2 months, we understand that they can't get the full 2 months salary, but at least they must get a month's salary for a person who is actually working full time. So that's what the second bullet is about. So any grade, type, occupation govern, in which event the employee concerned shall be entitled to be paid the difference between what he or she has earned in that period of 2 months and 1 month's remuneration or wage. Okay, so let's do it this way. The NEC wage for grade X is $20, okay? You have engaged me to work for you for 2 months, and you are paying me $5 every month. The total, the number of hours, if we add them, it's $5. So for 2 months, I earn $10, isn't it? But if I had worked full time, in 1 month, I would have earned $20. So the statute says the employee in that case is entitled to be paid the other $10. Is that clear? Should I take it again? It's clear, isn't it? All right. So if it isn't, then we can always clarify this in plenary. The last one, if such contracts are prohibited by the collective bargaining agreement governing the undertaking, industry, and grade and type of occupation. So remember, I said the statute does not prohibit you from hiring a person on an hourly basis. But if at any C level you have agreed that we don't allow such in our sector, then an employer cannot do that. Okay? So the three are exceptions to in what circumstances can an employer hire a person in an hourly contract. Firstly, your terms should not prohibit the person from getting employed elsewhere during those times that is not working for you. Secondly, whatever you are giving them must be, when aggregated for only a period of 2 months, be enough or more than the amount paid for a person in a month in terms of a CBA. And lastly, that kind of a contract must not be prohibited by the CBA applicable in that particular industry. I think that's what the new Section 18A talks about. Okay, I think it's also because there is now a proliferation of these kind of contracts where employers sometimes are choosing that they want a person for a particular time, and also in some other sectors, say for example broadcasting. I think Kumbi can attest to that. We know that our broadcasters or DJs, they work I think for 3 hours or 4 hours in a day, and then they also want to come and MC here. And Kumbi's employer says, no, you can't do that, but you are not doing anything. So I think that's also one of the things that it is meant to do. Okay, so like I said, apologies for having left that one out. It was clearly inadvertent. So let's go to the fourth segment, ladies and gentlemen. So fourth segment starts with amending Section 28. So you will notice, just so that we don't have confusion, I've just followed the order in the Amendment Act, just removing the provisions that my learning colleague is dealing with. So even though I'm referring to the provisions in the Act and not in the amendment, I think if you just follow them in that order, you will see that I'm taking that similar order. And I also, even those who made the program did the same. Okay, so the first section in this segment is Section 28, which deals with the prescription of membership fees. So the minister is no longer required to prescribe membership fees for trade unions, employers, associations, or federations. So I'm going to talk about employers. I'm going to talk about trade unions, I'm going to talk about employers associations, and I'm going to talk about federations when I deal with Section 28, Section 70, Section 80, Section 56, all those sections. So I'm just going to say union, association, or federation. By that, I'm referring to the trade union, I'm referring to the employers association, I'm referring to the employers or employees federation. I want that clear so that sometimes I may not say them all, but you know that these provisions affect when you are applying to register as a trade union, when you are applying to register as an employers association, when you are applying to register as an employers federation or employee federation, the laws are the same. So there is now no requirement for the minister to prescribe that you are supposed to pay or to have membership fees kept at this level. It was provided for in Section 28, and it allowed the minister to prescribe that in a statutory instrument that is no longer there. So I think it's just one of those issues that have to do with government moving towards the ILO requirement that there is very little interference with the affairs of these associations that we are in, which in some sense are voluntary associations. So you guys decide what should be paid, and so the minister is no longer involved in that. That is the simple essence of the amendment in Section 28. We move on to the next one. This one deals with accreditation. So your biggest takeaway from this conference relating to accreditation is that you must now know that whereas in the previous dispensation, when you are applying to register a union, association, or federation, the other parties who are opposed were entitled to make submissions, and then the registrar would invite you for accreditation proceedings, like that hearing where you are saying they must not be registered and they are saying they should be registered. In respect of registration, that is no longer allowed. So there is no more need for accreditation proceedings when you are applying to register. But there still remains need for accreditation when it's an application for rescission, suspension, or variation of a registration. I hope that should be clear. So sections 33, 36 subsection 1, 39 subsection 3, and 41A, all of them remove every reference that was there in the Act to say, to talk about accreditation in respect of applications for registration. The process of registering a union, an association or federation has been significantly simplified. And I think the trend had started manifesting in the last 2 years or so. I think the registrar was at pains to explain to a lot of people that, look, now we don't ask a lot of questions. If a person has a constitution that complies with the law, has membership, has shown us all that the Act says, then let's register them, because that was what the right in the constitution requires. So we are going to have a lot of unions, I think. We are going to have a lot of employers associations, rival employers associations, rival unions or federations, in my view, because of this. And I think it's a question of survival of the fittest. If the minister has simply said, I'm not registering, or the registrar said, I'm not registering, but it does not give reasons. So the Administrative Justice Act has got a set of provisions that allow for administrative justice in the conduct of business by administrative authorities, which are normally our government and quasi-government entities. Okay, so the legislature, for some reason again, does not trust the Labour Court. Says go to the Administrative Justice Act. The Administrative Justice Act allows you to approach the High Court when you feel you want to, the High Court or the Admin Court in different circumstances. You have not been given a reason for an administrative decision. You approach either High Court or Admin Court. There are different provisions that allow you to go to either of those courts. If a refusal has been done, but you feel that there's no justification for such a refusal, you again approach the High Court or the Admin Court. There is no Labour Court in that matrix. So by saying, make this application in terms of the Administrative Justice Act, we are being told indirectly that please don't go anywhere close to the Labour Court. And I ask myself, this is a purely Labour issue. Why are we going there? Why are we going there? So I think this is also part of the complaint that I raised earlier, that look, I still think, and perhaps I will get an explanation from the ministry people that are here. Why are they so skeptical about the capacity of their Labour Court judges? Because you see, if it's we who practice daily, we have our own views about judges, and these views may not necessarily be true. If you give me a case which is not winnable on the facts and I go and I lose it, and I'm looking at you and I'm thinking, wow, I think I can't blame you, I can't blame me, who can I blame? The judge, because it's not there in my office, isn't it? I'll say, this judge does not know or something. People have different views about judges. But we have trust in the process of recruitment of judges in such a way that we bring the professionals to these courts. Okay? We have judges in the Labour Court who I think, understand these things, and some of them have actually moved to the High Court, which is a sign itself that these are judges who are capable. So why we can't just give them the power to deal with these issues, I totally don't understand it. And I hope somebody today will explain that to me. If they don't, I will continue complaining. So the jurisdiction here is given to the High Court and not to the Labour Court. Then we go next to the issue, to the amendment in section 34. So section 34 deals with applications for registration. So to avoid this mushrooming of briefcase unions, associations, or federation, the Act now requires that you specify your physical head office address and submit minutes of the meeting of the new organization and specify the leadership of the organization. So tell us, do you have an head office? Where is it? In fact, if you read the provision well, I don't know if I'm already not critiquing it. It's section 34, isn't it? I'll show you what it says. So it says, section 17 of the amendment, it introduces a subsection F which says, whether the trade union or employers organization has a head office at a physical address. So there must be an indication whether you have a head office at a physical address. It does not say provide the physical address. Tell us whether you have a head office. I think it's a drafting problem, isn't it? They wanted to say give us your address, but they said, well, tell us whether you have an address. We'll say yes, we have it. Okay, and then give it to me. Which act says I should give it to you? So that also is something that our drafters needed to think about. But I think the rationale is the same. Anyway, when you are applying, ideally you just put your address. But it says, look, there are others who are just registered. They are known at the ministry. On the ground, they have no office, nowhere. They are operating from someone's house or Boy Sky or something like that. So that is what the statute is trying to avoid. Since it is the legislature has now left everything to be run at those unions, the minister is not interfering. We want you at least to have somewhere where you are operating from. We want to know whether there's been a meeting of the organization and there are actually people, and we want to know your leadership. So I think it's a progressive amendment there. Let's go to section 34A. The Act now introduces a new section 34A, which requires the trade union, association, federation to submit on request or on a period specified. So you will notice that there are certain things like annual statements, they are supposed to be presented annually and all that, but it's either on request or in terms of a period indicated in there. Submit your yearly certified updated membership register. If you change address, you also should give that. If you fail to do so, the registrar should give you 60 days to say, hey, we asked you for this, or the year has lapsed, you have not given us an updated membership register. Therefore, we give you 60 days to comply. If you fail to comply on expiration of these 60 days, you get a suspension for 60 days. So the first 60 days is for you to comply. If you don't, then from the 61st day, you get another 60 days within which you are under suspension. And then that suspension takes away all benefits of registration. For unions, for employers associations, I think the lifeblood of these institutions is that they are membership driven, isn't it, in terms of contributions. So the check-off system is suspended. So an employer is entitled to say, we are not paying any union dues to this particular union or to this employers association, assuming they're coming from the employer, because you are on suspension. So suspension is very dire, so you need to comply with what the registrar would have said or what the law says you should, and you should be acquainted with that. The suspension can only be uplifted within those 60 days on compliance. If those 60 days lapse before you comply, then the certificate of registration is cancelled. So there's nothing else that needs to be done. They're not going to write to you and say, take note that the 60 days are expiring the next day. No, it simply says if the 6 days lapse, then your certificate of registration is cancelled. So I think it's just meant to elevate the importance of this kind of details being given. That gives the registrar and the minister an overview of what is happening, because they must be able, if asked in any policy meeting or whatever, to say, give us an indication of the number of employees that are in trade unions. They will have a membership register for each trade union. They should be able to speak to these issues. And sometimes they may request for other things which are not here, because it simply says on request, you need to avail those. Let's go to section 45, which deals with variation, suspension, or rescission of registration. Remember, I said earlier on, this is the provision which still allows for there to be accreditation. Now, the importance of accreditation at this stage, I think we can all relate compared to application. At application stage, one is asking to be given rights, and the Constitution has allowed that they be given. And so when they've met the requirements, they must be given. But at variation, at suspension and rescission, remember, the union, the employers association, or the federation itself can apply for variation, for registration, for rescission, or for suspension. But another entity can also make the application. A rival union, a rival employers association can apply that. I think you need to vary their scope. You need to suspend them. So imagine if that happens without accreditation. because some right is being taken from you. So the alteram partem rule, the need to hear a person before you take away their rights is then should then be, it kicks in and it should be respected. And it is in that respect that the legislature has said we still retain the need for accreditation. So if a person applies that trade union X or Federation X has to be, registration has to be suspended, for instance, surely that particular entity must be given a chance to be heard, isn't it? To say whether they should be suspended or they shouldn't. So accreditation remains in that respect. And also I highlight administrative justice requires that to be there. So there's now removal of the following considerations when considering an application for variation, rescission or suspension of union, association or federation. The desirability of reducing entities at the bargaining table, reverse onus of proving the desirability removed. Now I need to explain this a little bit. That you recall, Ms. Mango, remember when she was at registry and even my sister there, that one of the issues that we used to raise when we come in for applications for registration was that consider the desirability of reducing the number of entities that go for bargaining. So if we have got 4 trade unions in a particular sector and 2 more want to be registered, we would be saying to you, but why do we need to have 6? It actually complicates negotiations. Why do we need 4 or 5 employers associations when ASAS is doing a wonderful job like this? That used to be an issue, isn't it? Now the legislature is saying, just leave it there. If there are 20, leave them there. They will fight it out down there. And those who are doing well will also see themselves actually doing well. So that provision that required the registrar at variation to consider the desirability of reducing entities at the bargaining table is removed. And also because of that, when you argue that it is desirable that the number of entities be reduced, it is you who doesn't want the new entrant to be registered, isn't it? The onus then shifted to the new entrant, to the would-be new entrant, to prove that, in fact, it is desirable that we also join the party. You follow? So both the first one, the requirement, and this issue of the reverse onus is what the amendment removes in that amendment in section 45. Okay, let's go to section 51. The provision removed, so the new amendment removed the provision, the provision has been removed to give effect to right of freedom of association, no ministerial interference in the management of unions or associations of employers. I think this is an issue that the employees have been raising, that look, we don't want you to interfere in our management. So when we are doing our elections, I think a lot of trade unions, a lot of employers associations, whenever they would do an election, I think we've done a lot of disputes between unions where one of the issues, one of the grounds, advocate, is that there was no representative from the ministry to inspect or to say, or at the end of it or after the elections were done. It was so chaotic that there was no declaration. I'm sure the labor officers here will know. At the end of it all, there was some funny declaration that you would do, that now I, as the labor officer so-and-so, do hereby declare that these are the people, and then you read out the list of the new executive, isn't it? And because some of the elections ended in some kind of nasty way, there may not be enough time for the registrar to make that declaration. I remember dealing with a case where I was told, look, these people were never declared by the registrar. But these other guys are saying, but the registrar, the moment she wanted to speak, these guys were taking the mic, were switching everything off, so that declaration doesn't happen. So you could see the importance that people were actually putting in the presence of the registrar and the presence of the labor officer. So the statute says, no, it's no longer required. You do your elections there. If you call them, you are calling them just so that they also see what you are doing. But whether they are there or they are not there, the elections will stand. But let's assume someone is not happy with it. What happens? So the aggrieved candidate now complains to the minister that the election was either tainted by fraud, by unfairness, or coercion. So this is the application so the thing is, if the minister sends a labor officer and the labor officer is already involved in the process, and then you are supposed to challenge it. You challenge it to who? Because the person is representing the minister, isn't it, when they come? and they are there, and there's fraud and there's everything. So you are requesting the minister to set aside fraud that happened maybe in their side. So the law says let them do their election wherever they are. But if someone is unhappy, now go to the registrar and raise an issue. So if you are aggrieved in that election, so remember, a person who can only apply is an aggrieved candidate, an interested party. I think that's the language that the statute uses. You can complain in writing, and the grounds are there: fraud, unfairness, or coercion. I think you can put anything there that you can think of. The registrar conducts a due inquiry. Due inquiry simply means you hear all the parties that are involved. If I allege that XYZ bought all the delegates so that they vote for him or her, then you must be able to give evidence. But that XYZ must also be given a chance to make representations, and you hear. So the registrar conducts a due inquiry. Due inquiry does not necessarily mean that you must do a hearing. It may mean that you invite all the parties to make representations, or just find a way that each party is heard. So the statute uses the word due inquiry, does not say there must be a hearing. So just so that we are clear. Sometimes after making representations and getting a response, it's so clear that, look, there was fraud here, there was coercion, there was no fairness. It can't be an issue to say, but there was no hearing that was done. How did you come up to this conclusion? Okay, so the power of the minister to set aside, postpone, or regulate election, it is only retained as a consequence of the consideration of the complaint. So the minister, you notice in section 51, has powers to set aside, to postpone, to regulate. I think it's there's a list of those provisions in section 51. It should be subsection 2 or 3, I'm not sure, to those who have it with them. So the powers to do that are only exercisable when the minister is relating to a complaint by the aggrieved candidate, either who would have lost or would be complaining. Okay, so that is the essence of that amendment there. Collection of union dues in section 54 and 55, clauses 54, subsection 2, 3, 4, and 5A, which allowed ministerial involvement in collection of union dues, have now been repealed, and we've explained earlier on that it is in keeping with the non-interference aspect in the internal affairs of unions or associations. So you guys cannot complain anymore that these ministers, that the registrar is just everywhere. Everything that we want to do, they want to know. The statute is allowing you to do some things on your own. And so when the minister now requires information, you can now complain. Because we've left you to your devices. But you're doing it using members' contributions. So the minister has an interest now in ensuring that those contributions are being utilized well. And so the annual audited statements and all that then have to be submitted. And who are your leaders is also a thing that they need to know. Who are your members is something that they need to know. Do you still have members? If you no longer have members, just go and tell them, I no longer have any member, but I still want to remain. And then they'll ask you why. Something like that. So they must be aware of what is happening. Okay. Then section 55.5. It is not repealed, but like I said, I think this is also another drafting issue that you may take note of. They don't repeal subsection 5 of section 54, but you notice that that subsection is predicated on subsection 3 and 4. Once you repeal 3 and 4, you cannot retain subsection 5. So maybe take note. I hear there's some cleaning that may happen to the bill to deal with the issues that we raise. Okay, then section 55 is that one is completely repealed because that dealt with ministers' collection of dues and whatever, and a whole lot of issues that they included. I think that's the end of this segment. Thank you. I should proceed. I'm told that according to the program, Kumbi says this. I take it that I should continue running. Okay, I am just hoping that it's getting clearer as we are going. As they say that if there are issues that you feel are not clear, please just jot them down. We have a lot of discussions. Like I said, I refrained from putting so many comments on this so that we at least unpack it, just understand what does it have, and then we can always have the discussion. So let's go now to the fifth segment, which deals with statutory employment councils, which is an amendment to section 56. Now, I have been involved in litigation where people were saying, you have set and agreed as an NEC, and why are you asking me to be bound by what you've agreed, or a person wants to join a new union, a new association has been formed, they want to be a member. And this guy says, no, we are a voluntary association. Why we don't want you? And a person goes to court, different judges say different things. Some say it's a voluntary association, you can't force them. Some say, I think the Supreme Court has a judgment to that effect. But some other judges of the High Court were saying something different to say, yeah, well, it's voluntary, but everything about it is actually regulated by statute. So now, for the avoidance of doubt, all NECs, whether voluntary or otherwise, are now governed by the Labour Act. So they put that clause in so clear terms, so no one can wake up and say, this is our thing. We formed it when it was just the two of us. It was so difficult. So we don't want anyone else. It's no longer yours. Okay, it's ours together. So there are very interesting issues that I want to discuss to you in the last 2, 4, 6 bullets there, which have been introduced by the amendment, but which were not there in the previous act, but which you found in several NEC constitutions. And I know someone here looking at me as I speak who asked me for an opinion at some point to say, we are sharing seats. Here is our problem. How do we share them? Verification of membership, how do we do it? And I gave them an opinion. Unfortunately, the legislature has come up with a law that seems to go against what I told you, but that doesn't mean what I told you was wrong, because there was no law at that time, isn't it? So you can't say, he was wrong, the law was not there, isn't it? The law is coming because they know that we gave you those kind. It is those kind of opinions which then make them, no. I think let's clear this. Okay, so let's deal with that. So the first thing is the parity of votes in the NEC is now specified in the Act. It used to be a requirement that you put it in your constitution. Now it specifies clearly in the Act. Then proportional representation for employers. Get this right. Proportional representation should be there for both employers and employees. Now, for employers, it's based on the number of members of each employer member or employers association. Now, the Act starts, that section starts by defining employer member and employee member. It defines employer member as the employers association, isn't it? It defines employee member as the trade union. Do you get it? Now, when it says proportional representation for employers is based on the number of members of each employer, they are saying, if in your particular sector you've got 3 employers associations, the number of seats that you get is a proportion of those 3. We don't care about the employees that so it could be ASAS. It has how many employers? I don't know. That fall under it. We don't look at all that. We are looking at the number we're looking at the number of employers that are there, not the employees, sorry. Let me clarify that. So ASAS has employers under it. Say it has got 20. It is the number of employers that it has that we look at. If we go to the trade union, we are looking at the number of employees that each trade union has. So that is what you use to consider how many votes do you get. Do you have so many employees under your umbrella? Yes, so you get more seats. Do you have so many employers as an employers association? Do you have so many individual employers? So it could be 10 employers, but each employer employing two workers. But you may find yourself actually getting so many seats because you've got many employers. So I gave an opinion that clearly didn't align with that, because I felt, look, there must be a consideration of the number of employees that each particular employer carries, isn't it? But the statute is now clear that when we are talking of employers associations and their representation or verification of membership, let's look at how many members does a particular association have. How many employers fall under a particular association? So that is now in statute, no doubt about it. So you must be clear on it. Then if membership of a trade union or association can't qualify for a vote, the Constitution must provide for allocation of a fraction of a vote to the trade union or association concerned. When I talk about Section 82, I think you understand why this provision is there. But what they are saying is that let's say we have done our maths and we realize that for every trade union which has 10 employees, those 10 employees constitute a seat, isn't it? And then you have a trade union which has got 4 employees, just as an example. They can't get a seat, isn't it? The statute says give them a fraction of a seat. I don't know how that's done. But it says that. It says that you give. So the idea, as you see when we deal with Section 82, is to ensure that no one can say, I was not there, I was not involved, because there is something that comes in Section 82 that you will see. So the same applies for employers. If the number of actual employers that an employers association has is not enough to constitute what is considered a seat, because isn't it that, let's say we have 5 employers associations. Under these 5 employers associations, there is a total of 5 actual employers. I hope I'm not confusing you. 5 employers associations. If we aggregate all employers under these 5, they get to 100. So we then say, okay, we have 5 multiplied by 100. 5 into 100, it's what? It used to be 20. It's still 20. Okay, it's 20. So we say for every 20 employers that you have, you get a seat, isn't it? But if I come and I have 11, I'm not supposed to get a seat, isn't it? The statute says give them a fraction. I don't know what you have of a seat. I don't know, because at the end of the day, if it's a seat, then an actual human being will go, isn't it, and get into the deliberation. So if it's a fraction, I'm not pretty sure what goes in there. You send your leg or your head or whatever part of your body, I'm not sure. But that's what it says here. All right, so I think that must be clear. But if you then go to subsection 5, I think let's read subsection 5, sorry. Subsection 5 seems to section 56, am I reading the correct one? Actually, one subsection 9, my apologies. Subsection 9. So I'm contrasting subsection 9 with 5. The one that talks about getting a fraction of a seat is subsection 5. Okay. So subsection 9 then says, where the membership of a particular trade union or employers organization is not adequate for it to be allocated a seat, it may, at the discretion of the Employment Council, be admitted as an observer in Employment Council meetings. What are they saying? If you have 11, remember that example that I gave, employers, instead of the required 20 to constitute a seat, at the discretion of the Employment Council, you should be admitted as an observer. That's what this provision says. But the 1 in 5 says, give them a fraction. Now, I will tell you, maybe in plenary, how you get around that. Okay. You will notice that subsection 5 says your constitution should have it. Subsection 9 says this should happen. So I think you guys understand what you go with there. So where there's dispute as to allocation of seats, you go to the registrar. I think this is a welcome amendment. I think we had so many problems with such disputes and people fighting and doing all sorts of things and citing the registrar, and the registrar is involved, the registrar and the other party is saying, ask the registrar. They know that in this industry, this is what happens. The registrar can't say because they are a party, or certain things are required from the registrar, and the registrar can't give them because they are a party. Now, you actually go to the registrar because they are actually the ones that superintend over the labor affairs anyway. So if there's a dispute as to allocation of seats, you go to the registrar. Get it? So what it means is that when you allocate your seats, allocate them on your own there. It does not cure it to go and ask that a labor officer come, because you also do it, to say, labor officer should come, so that the labor officer was there. No, because when there's a dispute, the matter goes there. So this allocation should be happening amongst you, because remember, there's parity in between the parties, the employer and the employee side. We expect that you sort yourselves out. If you fail, then you go to the registrar. So if you invite the registrar when you are fighting and then you don't understand each other, what do you do then? You are then supposed to go in terms of... So the law wants you to do your own things, but then you then go to the registrar when you have a dispute. So those who would have failed, those who would have gotten observer status instead of a fraction will go and say, no, we were supposed to be given a fraction. Why did we get observer status? Or those who were given observer status may say, no, we actually wanted a fraction, whichever way. So the aggrieved party, so the registrar, again, hears parties. here's the complainant, here's the respondent, and then makes a decision. That decision is again appealable to the labor court. Okay, let's go to section 58. The constitution of an NEC should provide for the admission of new parties in accordance with the new section 56. So what we explained in section 56 tells you now, those who were saying, Chin Chedu, this is our NEC, we won't admit others, that the expectation is that every employer and every employee who is in that sector, who wants to be part, should be part. We think that it should have been clear in section 56, but just because there are others who still think that it's theirs, section 58 now says, your constitution as an NEC should provide, as a matter of course, for the admission of new parties in accordance with the new section 50. So you shouldn't ask to say, what do they do? How do they get in and stuff? Once you admit them, then the criteria for admitting members should be there. I think there's a provision that I didn't deal with in the previous slide on section 56. Please take us back there. Bullet point number 4. Previous slide, please. Seats allocation or votes are now subject to annual review. I didn't talk about that, isn't it? Yeah, please know that. So if you allocate seats today, and you get your number of seats, you get your fraction, you get whatever, at the end of the year, we do it again. We do it again. So this process is going to be an annual process. Why? Because others who got a fraction now may have gone down and worked to make sure that they get one. So if you wait until you get your next elections, surely these people won't be having a voice. The idea is that those who have more should get more representation. So at the end of the year, let's go and review. So if, for example, so as a constitution, just as a tip, you could have a constitution that says, if you are admitted, if you are registered as a new member, you will be admitted at the next annual review. You can do that if you can make that provision in your constitution, because this provision says it should be in your constitution. Okay, so I was on section 58, so the constitution should have that. So if your constitutions don't have that, please go and amend them and have that done. So this is, again, like I say, a reaction to several judgments that conflicted on whether or not such new members have automatic right of admission. I think there have been several cases. The sugar milling case, I remember I was involved in that, and a couple of others where that issue has arisen. How am I doing, Kombi? What time? I'm okay. Okay, thank you. Okay. Section 63, ladies and gentlemen, is the one that deals with the labor, the designated agent's exclusive jurisdiction for all disputes and unfair labor practices that occur in the particular area for which the NEC is registered. Now, it has made serious amendments, which I think as employers we must be aware of, as employees we must be aware of, and as NECs also they must be aware of. The first one is that there is no longer exclusive jurisdiction for the DA, even for matters in your own area. That exclusive jurisdiction is now taken away in specified circumstances. The labor officer can get involved even when an NEC exists with a DA. And what are those circumstances? The first one, if a matter is not decided during the first 30 days after the date when the dispute or unfair labor practice arose, the labor officer may assume jurisdiction provided proceedings to determine that dispute have not earlier commenced before a DA. Let's break that down. I don't know if I should critique it now, or maybe let me leave it there, but let's just understand it this way. If 30 days lapse after a dispute or an unfair labor practice in your particular sector where you are registered as a DA, and you have not done anything about it, then whoever has that dispute is allowed to approach the labor office and say, this one no longer has jurisdiction because the dispute, 30 days have lapsed, and nothing has been done about it. So the labor officer can get involved if within 30 days of a dispute arising, as a DA you have not done anything about it. And when the reference is made to the labor officer, it must be done at a time when those proceedings have not started before the DA. But I'll just give you my very quick problem with that provision, where it says that italicized part, 30 days after the date when the dispute or unfair labor practice arose. A dispute may arise at a workplace. The DA does not stay there. And no one tells the DA, no one brings it to the DA. And then the employee says, no, we've not been paid overtime. It's now 2 months we've been raising with the employer. The DA has done nothing about it. So the assumption is that the DA is carrying out inspections. They are asking the employers, can you tell us what's happening? So you must know the dispute. If you haven't dealt with it within 30 days, then I'm referring it to a labor officer. I proposed in that write-up that I talked about earlier, when I got this provision in the bill, to say, I think what should have been put in there was that it's 30 days from when the dispute is referred to a labor officer, or it comes to the attention of the DA. Because it is only then when we can now say, this person is not doing anything. But I also see within it a deliberate attempt to ensure that NECs take seriously the inspection mandate. Because it is only, was disputes, if you notice section 93, it says, when a dispute is referred or it is otherwise come to your attention, it means that you can actually know of a dispute by reference, by parties, but you can also just get there and say, I'm inspecting and realize, no, but you are underpaying the employees. Come on whatever date, I'm going to hear this matter. It's allowed, because the statute allows you to find out on your own. So I think it was just me trying to make sense of reference to when the dispute arose, to say maybe the legislature is putting the NECs on their toes to say, do your best in inspection and find out if there are disputes, solve them. If you don't do so in 30 days, you're in trouble, because this dispute will be taken elsewhere. Now remember, in NECs, some of them have 2 DAs, some of them have 3 DAs. We'll talk about that very shortly. If we know that this particular DA, I know employers, some employers dealt with a certain matter, saying, no, this DA is biased against us because you always underpay, and employees take the matter to the DA, and the DA always rules against you. And you're thinking, no, this one. So you hold on to your dispute until 30 days, and then you take it to a labor officer, where you know that I'm not in team, you can't go and go to a particular DA, and like at the labor office, you can be given any person, isn't it? So forum shopping of persons who deal with matters can actually happen, because that is why I had proposed that maybe let's say up from when the dispute is brought to the attention. But as I said, it is after 30 days after the date when the dispute or unfair labor practice arose. So DAs, please go and do your work. But obviously you can't refer a dispute to a labor officer when, say for example, the labor officer gets wind of the fact that on Monday you want to go and you are waiting for other employees so that you team up together and go to the DA, you go to the labor officer. The DA on Friday then registers a dispute and then invites you for a hearing. As you are going to the labor officer, you are met with an employer who says, we already have a notification for this. So the statute says, provided that proceedings to determine that dispute have not earlier commenced. So commencement is not finalization. Okay. So there is that also loophole that is plugged there. Registrar is now empowered to receive complaints against DAs from any interested party or from a labor officer. So as a labor officer, you are just walking about as the sons of men were doing in the Job story. They were just going around, isn't it? And the labor officer, you are passing through and you are supervising your DA, and you realize, this DA is doing nothing. And you refer the complaint to the registrar, or an interested party can also raise that to the registrar to say the DA has failed to deal with a dispute or is unduly delaying the exercise of their statutory mandate, or they are conducting themselves in an improper manner. The registrar is entitled to conduct an inquiry. But understand this is not only restricted to hearing disputes. It talks of improperly failure or undue delay in exercising the statutory mandate. So it talks of failure or undue delay in exercising statutory mandate. It also talks of conducting yourself in an improper manner. So if a labor officer thinks that the way this DA is conducting themselves, they are not doing it properly, they are not dressing like a DA, they are coming like a disc jockey. I mean, they can go and say it's not proper for a DA to be like this, isn't it? Someone was talking when we were at tea that that provision which used to say that you must, I mean, it's ISO1 which say that there must be side meetings done, and she was saying, look, at the labor office, I mean, you look at the offices, they are already few. If you are told to do side meetings, where do you go? They should have said outside meetings or something. So they can. So you notice it's really not just about a dispute. It's just about how the DA conducts themselves, how you carry out your inspections, your general Section 63 mandate. If you're not doing it well, a party who is interested can complain, or a labor officer can complain. Okay. So what can the registrar do after doing the inquiry? Remember, you can see all these things before a drastic action is taken. An inquiry must be done. This must be noted, particularly from the ministry's attention. You see, there are people who bring disputes and say, it's so brazen, it's so clear that what DAX is doing is unlawful. And you as registrar, you look at it, you think, yeah, they cannot be anything that justify this. And then before we know it, you've already written your letter, which is signed. And then the other person takes it as an issue. I was not heard. So after the inquiry is conducted, the appointment of a DA can be withdrawn only for failure to exercise mandate. They can direct the NEC to allocate a matter to another DA in the case of a delay in finalizing a dispute. But the registrar can also refer the matter to a labor officer in the case of a delay in finalizing a dispute. So where the complaint is that the dispute is taking long, there are two options. The registrar can say to the NEC, can you appoint another DA? Or they can actually refer the matter to another labor officer, so that the DA actually doesn't have jurisdiction. Okay, let's move on to the next one. Section 74, paid educational leave, now a subject of collective bargaining negotiations. Remember, earlier we were talking about paid educational leave is now a subject for discussion at Works Council level. Remember that? Now it's at NEC level. Okay. So it's also one of the issues. Remember, Section 74 lists the issues that you can discuss and put in your CBA. Not an exhaustive list, but for the avoidance of doubt, put the issue of educational leave. And I've said that it's in recognition of ILO Convention 140 on paid educational leave. And again, the minister is now a party to negotiations in respect of state entities with equal footing with the employer. I don't know the question that I wanted, but I know now that you are saying to yourself, the employer that we are talking about is already there as a seat, and the statute says the minister is an employer with equal footing. What does it mean? Does it mean one substitutes the other? Can we have negotiations between people in an industry with a minister or a ministerial representative? I think it's an issue that Amnorwe is looking at me. I know he has an explanation. I think, I don't know if there are others who feel, I think when we discuss, let's talk about this, maybe make me see sense in that. I still think that when a state entity exists, it is given a board. It is directors, it is senior managers, it is all those people. Surely if we don't trust those people to do bargaining to such an extent that we now have a minister also or a representative coming, it could be something else. But let's talk about it in our discussions. Let's move on. I acknowledge the presence of Mr. Mcheche. Is now with us. Welcome, sir. It's a pleasure to be here. He trained me. I think you heard from my resume. That's where I started. I still have a lot of things that came from there. All right, so registration and amendments of CBA, Section 79 and 81, I put them together. The minister no longer has veto power to register a CBA on the ground that it appears to him that its terms are unfair or unreasonable. I remember there was that provision that says if you have done a CBA and you have submitted for registration and the minister considers that its terms are unfair or unreasonable, the minister could actually veto and say, no, sort it out. Now that power is no longer there. But the parties, and the understanding is that the parties have the power or the wherewithal to determine what is fair or reasonable to them. However, when a minister considers that the terms of a CBA are inconsistent with the law, so remember there were two bases upon which the minister could veto in a registration: unfairness or unreasonableness, and inconsistency with any law. So the unfairness or unreasonable part is what has been repealed. But what remains is inconsistency with any law or contrary to public interest. And that can happen before registration, or even after registration, the minister realizes that this is now inconsistent with any law or it is contrary to public interest. He or she should specify in writing for the attention of the parties to renegotiate in absolute good faith. So the issue is taken back. The registration is withheld for some time. Let's move on. Section 82 has now been amended, and now you have the right to just, equitable, and satisfactory conditions of work as espoused in Section 65(4) of the Constitution. Now requires that the provisions of CBAs be applied to all members in a particular sector. I think that is what that provision is about, and such the collective bargaining process must be free for all. For that reason, every employer or employee is now entitled to freely engage in collective bargaining, directly or indirectly, under Section 56. So there's a provision under that section, that amendment, Section 82, that says every employer or employee in a sector is free to engage. Take that right, directly or indirectly. So the indirect representation is what Section 56 is about. It's what happens at NEC, isn't it? You are represented by your employers association or by employee, by trade unions. But it also says directly. So the question that you ask is that if it is not in terms of Section 56, what does directly means? Does it mean that a particular employer on its own should also be admitted at NEC? Does it mean that a particular employee who feels that, look, I don't trust these trade unions, I want to go on my own, can they do that? Because there's also the use of direct or indirectly. And so there's also that problem that arises. We will discuss that. Then the failure to engage in collective bargaining is not a lawful excuse for failing to abide by a registered CBA freely negotiated in a particular industry. So this is a provision that has been inserted slightly before Section 82 subsection 1. I think they call it Section 82 subsection A1. It comes just before subsection 1, which then says when a CBA has been negotiated and registered, it is binding on everyone. So before that, they've put this, because there was a little litigation that came with people who say, they've negotiated their CBA, I was not there, I was not involved, why should I be bound? Okay, so the statute has now said, no, there is a constitutional requirement that there is just, equitable, and satisfactory conditions of work. So what happens at company X should also be happening at company Y if they are in the same sector. For that reason, you are very free to attend and be part of any negotiations, whether directly or indirectly. The direct one, that's what we said, I don't know how that will be done, but it allows you. So they then say, having been given that leeway, it is not an excuse for you to say, I was not involved. If you don't avail yourself of the opportunity to go and be part of the negotiations, you go and pester the NEC, we want to be made a member as an association, as a new association, so that we represent our particular members. If you don't do that and the CBA comes, you can then complain and then you are bound. Okay. Can you take us to the next one? I think that should be the last one. So I still think that there is a provision that I must talk about in Section 63. About labor officers. I think I omitted that, but I remember it is there. Let's just look at it. Okay, no, I'll deal with it. It's there under schedule of minor amendments. Okay, it's coming. Okay, am I done for now, isn't it? Okay, thank you.
Thank you so much for that, for those sessions 4 and 5. Thank you so much, Advocate. So if you ever wondered what it is like to attend law school, I think we've been in session since morning, and we've been in lecture theatres listening to legal opinion on the Labour Amendment Act. Yeah, so it's been tough being in class. Our next presentation is focusing on the powers of the Labour Officer, employment codes of conduct, liability of persons engaged in unlawful collective action, cessation of collective job action, and offences under Part 8 of the Act. And to take us through this part of the presentation, help me welcome Tsitsi Mazikana, Managing Partner, Lunga Mazikana Investments and Corporate Attorneys. A round of applause for her as she comes through.
Okay, thank you, Kumbi. Ladies and gentlemen, this is my final segment of the presentation. So to start with, I'll attend to the amendment of Section 93, which is the powers of the labor officers. Amendment Act introduces the effect of certificate of settlement. In the previous act, there was no effect that was given expressly by the certificate of settlement, which would have been reduced into writing by the labor officer. With the income of the Amendment Act, this certificate of settlement is given an effect of a judgment of a competent court in a civil nature. So what happens is where a party has received a certificate of settlement in their favor and the responsible person has not complied with that certificate, with the terms of the settlement, the aggrieved party may take that settlement to an appropriate court for registration through a civil action for enforcement. We also notice that the new section, it sets out the procedure where parties have failed to settle the dispute. Contrary to the previous act, you notice that the labor officer's powers to make a determination have been taken away in the Amendment Act. Where the labor officer has issued a certificate of no settlement at the lapse of 30 days of attempting to settle the dispute, if the dispute is a dispute of a right of interest, then the matter will be taken for compulsory arbitration, and this is compulsory. And this is also mandatory. There is no negotiation around it. And if the dispute is a dispute of right, the matter or the dispute may be referred for voluntary arbitration or for compulsory arbitration, depending on what the parties have agreed on. It is also provided that at the lapse of 30 days, the parties may agree to extend the time within which the labor officer may try to attempt to settle the dispute. And there's also an introduction of a recourse to an aggrieved party where the labor officer has not issued a certificate of no settlement within the 30 days or an extension that the parties would have agreed on. So this is when the parties or the aggrieved party is permitted to refer the matter to the labor court. The labor court will give a judgment or a determination which confirms with Section 89(2)(c), which is either a remittance of the matter back to the labor officer or a different labor officer for determination, or the other listed recourse or possible orders that the labor court may issue in terms of Section 89, subsection 2C. And Section 93 also indicates that where a dispute involves an employer which is a statutory corporation, statutory body, or an entity wholly or predominantly controlled by the state, the minister of that particular entity shall be deemed to be a party on an equal footing with such employer. And that party and that minister, that relevant minister, will be a party to the dispute. So if a minister is held to be a party on an equal footing, this means that the minister and the employer will be jointly and severally liable for the dispute that is for the unfair labor practice that has been committed by the employer. You also notice that the Amendment Act, having removed the power of the labor officer to make a determination, the need to have determinations by the labor officer to register them or to have them confirmed by the labor court has fallen away. This means that we have a progressive development with the Labor Amendment Act, where we are dealing away with the cumbersome and bureaucratic processes where an employee has obtained a draft ruling from a labor officer, and you still have to follow through with the labor officer to have that ruling confirmed in the labor court. After that, you still have to go back to the labor officer to take that labor court order and judgment to a competent court for registration so that you may be able to enforce it. Theoretically, it was the responsibility of the labor officer to follow through their ruling as well as the labor court judgment which they would have confirmed for registration and enforcement purposes. But practically, we were noticing that it was the employee concerned who would take it upon themselves to make an application in the labor court in the name of the labor officer concerned, because the labor officer has no interest, isn't it? So it's up to the employee to then follow through and incur all the costs for them to secure a judgment which is enforceable. But this was a tax on the employee, because the employee who has lost their employment, mostly, I've noticed that most labor disputes would be on financial loss. There's underpayment, loss of employment, all those things. And you've lost your employment or income, you're struggling, and then you go to the labor officer. You get a short-lived joy, you get a draft ruling. You have to follow through to the labor officer. If the labor officer leaves employment, shows no interest, or anything happens to them, then it means you cannot enforce that ruling anymore. You have to start the process afresh. But the Labor Amendment Act has come in to say that the labor officer's duty ends with either a certificate of settlement or a certificate of no settlement. Then you take it up from there. You also notice that this Labor Amendment Act comes in at a period where other employees are holding draft rulings and labor court judgments which involve the labor officers. Most will be asking what then happens to those judgments and draft rulings. But the Amendment Act is coming in with a relief in the transitional provisions, which is Section 128, which provides that that draft ruling that was not registered with the labor court shall be deemed to be a judgment or ruling of the labor officer for execution purposes and shall be registered in the appropriate court. For those holding the draft rulings, the procedure is the draft rulings will be taken to an appropriate court for registration. We then come to those who are holding labor court judgments which were confirmed by the labor court and having been issued by the labor officers. Previously, they would have gone through the labor officer for application for registration in appropriate courts, which was done through Section 93, subsection 5 or 7, I can't remember. But now that power has been taken away from the labor officer, and in terms of the new Amendment Act, this means that the employee concerned will have to revert back to Section 92, 92.3b, 92b3. I'm mixing it up in my mind, but That's the provision that the employee has, that the party who is holding a judgment should take to register the judgment to an appropriate court. Now, the challenge that will come in will be where a labor officer had issued a ruling which is not sounding in money. I think we need to take a change in the common law position, because the registration courts, Magistrates Court or High Court, there is a common law position that you cannot register a judgment which is not sounding in money. But now one person is holding a judgment, or maybe a principal draft ruling which is not sounding in money. We have a tall order in trying to convince the registration courts that the matter may be referred back to the labor officer for quantification, but in terms of what law? There's a lacuna in that aspect. And also, I'm not seeing the registration court getting into the merits of quantification of judgment on matters that they are not privy to the facts. Or alternatively, it means that one has to apply to a certain court to have the ruling quantified. But again, that will be a problem, because that aspect is not covered in the transitional provisions of the Amendment Act. I hope we'll get assistance on that. And then we have an amendment, Section 31, which is seeking to amend Section 101 of the Principal Act, the Employment Codes of Conduct. In addition to the prescribed manner that the application for registration of an employment code, there is now a requirement of payment of a prescribed fee. I believe there will be regulations which govern the fees or the gazetted prescribed fees for registration of an employment code. This clause also introduces the requirement to periodically review every registered employment code of conduct after every 5 years. It is also provided that if at the lapse of 5 years, an extension period of 3 months is given to employment councils, employers, for them to register a review of their employment code. And if they do not register at the lapse of those 3 months extension, then the registered employment code will be deregistered. And that seems to be automatic, with no notice and no reminder that employer, 5 years is up, 3 months extension is up, you have to register your reviewed employment code. Once the registered employment code has been deregistered in terms of this provision, then it automatically means that that undertaking shall revert back to the model code of conduct for grievance and disciplinary procedures. The Amendment Act also provides that at the conclusion of disciplinary or grievance proceedings, regardless of what your registered employment code states, the appeal shall lie with the labor officer, and this will be within 30 days of conclusion of the proceedings. So this means that to those who had their appeals lying in the labor court or with the DA, the Labor Amendment Act makes it mandatory that every appeal shall lie with the labor officer at the lapse of 30 days. So this calls for employers to amend and go through their registered code of conduct and effect this change, because even if there is a clause that relates to an appeals body somewhere else, the Labour Act indicates that it has to go to the Labour officer. Employers are also called upon to effectively change or move with times to amend their employment code of conducts to comply with the provisions of the Amendment Act. Otherwise, you have an influx of review proceedings emanating from the code of conduct which do not comply with the requirements of the Labour Act as amended. We move on to Section 32, which seeks to amend Section 109, which is the liability of persons engaged in unlawful collective action. The clause creates a distinction between the liability that is attached to people who engage in unlawful job action in a case where essential services are involved and any other cases. You notice that the penalty that is attached to unlawful collective action for essential services is a fine not exceeding level 14 or imprisonment to a period not exceeding 5 years. This creates confusion. I don't know what the legislators were thinking, because I've noticed that the other clauses, they speak to a fine of level 14 and an imprisonment not exceeding 10 years. But with this one, there is a fine of not exceeding level 14, but the imprisonment is not exceeding 5 years. So, Advocate Magogo, I think our assumption in the retrenchment clause is wrong because it doesn't follow that level 12 we have an alternative of 10 years imprisonment. In this case, we have level 14, which is alternated by a period not exceeding 5 years. I don't know what motivated that difference. You also notice that for any other cases which are not essential services, the fine that is imposed is a fine not exceeding level 14 or imprisonment not exceeding 1 year. So it looks like we are more interested in fines than the alternating criminal imprisonment. There's also an amendment that comes in the Amendment Act. It seeks to remove the requirements or the factors to be considered, or rather the test that is used in ascertaining the conviction of people who have breached or who have engaged in unlawful collective actions. In the previous act, it referred to the POSA, which has since been repealed, and they have amended it to include the Criminal Law Codification and Reform Act. Section 33, which seeks to amend Section 111 of the Labour Act, which refers to cessation of collective job action, has been repealed in its entirety. As a result, I do not know what the legislators anticipated in the circumstances where the cause of action has since been resolved. There is no provision that speaks to what happens when the reason why people have engaged in a collective job action have been dealt with. This was captured in Section 111, but it's no longer there. We move on to Section 34, which relates to offences under Part 8, and this is an amendment to Section 112. The clause amends Section 112, and it differentiates between the liability attached to people who engage in unlawful job action, so where essential services are involved and any other cases. So you find that, like Section 109, Section 112's major amendment is on differentiating essential services and any other action, any other services. So you realize that the offenses that are created in section 112 is contravention of section 104 subsection 3, which is the job action, or section 105, the locals and actions connected therewith, and a breach of a direction made in terms of section 106 subsections 2 subparagraph B, which is the show cause order or the terms of a disposal order. And a breach of these offenses, if the collective job action relates to an essential services, it's a fine not exceeding level 14 and imprisonment for a period not exceeding 5 years, or to both fine and imprisonment. In any other case, it's a fine not exceeding level 14, or where there is failure to pay the fine, and imprisonment not exceeding 1 year. And in determining the sentence that is appropriate to any convicted person in terms of this provision, the terms of any show cause order or disposal order that has been issued shall be taken into consideration. So in conclusion, it is imperative for the employers to take note of the changes that have been brought by the Amendment Act and effect them in their employment structures, contracts of employment, codes of conduct, and in their handling of internal job disputes, so that they will avoid unnecessarily being dragged to Ministry of Labour, retrenchment boards, and Labour Court over issues that can be avoided. And this is the end of my presentation.
Round of applause for her. Thank you. I think we'll have one more presentation, but I think we'll rest Advocate Magogo and bring forward the presentation by Mr. Mucheche. And he's looking at the advantages and disadvantages of the Amendment Act. And we just need to just highlight his brief profile. We've already highlighted to the fact that he's an author, a legal author, but he's also founder and
president of ZimLaw, former University of Zimbabwe Executive Dean of Law, legal practitioner, arbitrator, Pan-African legal scholar, legal author, international legal researcher, labor and business expert, senior partner at Caleb, Mucheche and Partners Law Chambers. A round of applause for him, ladies and gentlemen.
Ladies and gentlemen, we are going to go through the advantages and disadvantages of the Labour Amendment Act number 11 of 2023, which is shortened Labour Amendment Act 2023. I appreciate my learned colleagues, Benjamin and Tsitsi, for the scintillating presentations. Just as a way of a joke, we address each other as learned friends, lawyers who address each other as learned friends. So there's a time in Parliament when one backbencher, a member of Parliament, said that I want to agree with my learned friend, Dr. Edison Zobo, and he retorted saying that you are neither learned nor my friend. Anyway, the issue of learned friend is only a title for lawyers. No matter how many qualifications you may have, you in court, you can't call yourself or allege that you're a learned friend. You'll be quickly corrected by the presiding officer, who could be a magistrate or a judge. Labour Amendment Act number 11 of 2023 has introduced far-reaching legal provisions. My learned friends have already touched on some of the effects that it has brought about. In summary, some of the notable advantages that the Amendment Act has introduced is in relation to maternity leave You are aware that the limits that used to exist in relation to maternity leave have been scrapped, where the law under Section 18 used to say that a female employee must have served for at least 1 year to qualify, and also where there was a limitation of the number of times that has since been removed from 3 times to unlimited. This is one of an advantage, but it's also a disadvantage. It's a disadvantage in the sense that there may be some discrimination that may actually happen to young female employees. Capitalism is obsessed generally with the profits. So to imagine, for example, mining industry, to have a female employee who can go on maternity leave for unlimited number of times. For example, perhaps one can be so fertile to be like the mother of the 12 tribes of Israel, or some can even go up to 20, 30. Every year, having a child and the employer paying. It's unrealistic. Practically speaking, government ought to have introduced a maternity leave fund by creating some kind of a platform, either it's ZimDev or ONASA, to try and address this issue. It's a positive development to introduce maternity leave benefit to align with Section 65, subsection 7 of the Constitution, but practically speaking, we are going to have a situation where perhaps those who have reached menopause are the ones who may easily get employed when it comes to female employees. I'm not trying to support any issues that will lead to discrimination, but looking at the fact that we are a developing nation, we may not have the capacity to study patterns of employers to see how many are discriminated against young female employees. So to address this issue, I am of the view that there's need for a further amendment to ensure that female employees enjoy maternity leave fully and practically without hindrances, and that may entail creating some maternity leave fund, which government may also need to rethink and amend this provision. The idea of aligning our Labour Act with the Constitution is very commendable, but we also look at the after effects. What are the unintended consequences? And I've already highlighted that we may see female employees being discriminated against. Another contentious amendment is in relation to Section 12 of the Labour Act. There is an advantage that the common law termination notice has been removed in situations of no fault. Where an employer has committed no act of misconduct, the common law right of the employer has been annihilated by the new Section 12 of the Labour Act, Section 12.4a, introduced by Section 8 of Labour Amendment number 11 of 2023. However, there are subtle provisions in that clause. For instance, when it comes to termination by an employee, it's easier. Resignation and retirement, those are very clear-cut provisions. Voluntary resignation is a unilateral termination of employment which does not require the consent of the employer. Once you resign, I'm aware of some employers who would say that we are going to communicate our response to a resignation. As long as it is a voluntary resignation, it's unilateral, it does not require consent or rejection by the employer, it's automatic, it takes automatic legal effect. However, if it is involuntary resignation, that's where you go to Section 12.3a, constructive dismissal. There are some situations where an employee can resign without their own volition. Under those circumstances, that employee can actually have a comeback like an avenging spirit, claiming constructive dismissal. Now, there is a very subtle legal provision under the new Section 4a. The common law diehard has been brought back via the back door. Termination or notice by the employer is now given as a right for a situation of misconduct, for either breach of an express or implied condition of employment. If you check, the majority of contracts of employment have a subtle legal provision. You may not see it, but it speaks to summary dismissal without a hearing, where the employer suspects that you have committed a breach of an implied or express condition of employment. This is what the legal provision says. A contract of employment may be terminated only on the part of an employee by his or her resignation or retirement in the following case on the part of the employer. A, by mutual agreement in writing. Mutual agreement in writing is not a problem. It has no comebacks. Both the parties must have their signatures. Once you append your signatures, the legal principle, caveat subscripta rule, the signer beware, it is legally binding. Now, the second scenario, which is Section 4AB, for the breach of an express or implied term of contract upon such breach being verified after due inquiry under Employment Code. The phrase due inquiry does not mean a disciplinary hearing per se. Due inquiry inquiry means to ask for information. In the case of Julie Holdings versus Chanaiwa, it's a 2007 Supreme Court judgment. An employer wrote a report to an employee to say, can you answer to these allegations that are being leveled against, more or less like the preliminary or the prelude to a disciplinary hearing. The moment the employee responded, the employer proceeded to impose a dismissal penalty without an oral disciplinary hearing. And the Supreme Court agreed with that. Now we have that provision in our Labor Amendment Act 23. However, I appeal to HR practitioners and labor practitioners to really put on a human face and ensure that fairness is followed. Because a bad precedent gives birth to a bad precedent. We may need to amend our codes of conduct so that we define what due inquiry means. I would hasten to say that we need to define due inquiry to mean an oral disciplinary hearing. Where someone exercised the right to be heard, just like you are aware that the Supreme Court of Zimbabwe quoted in the case of Taylor versus Minister of Higher and Tertiary Education that God did not banish Adam and Eve without affording the right to be heard. God did not banish Adam and Eve from the Garden of Eden without affording them the right to be heard. The right to be heard is fundamental. It's a cardinal principle of law. It's also codified under Section 69. So we need to tailor-make our codes of conduct to allow the right to be heard. Of course, in this day of virtual hearings, the right to be heard does not mean the right to be seen. You can still lawfully conduct your virtual hearings and they will pass the legal test. If you go to your employment contract right now and you check and there is a clause that says that an employer can summarily terminate your contract for any implied for any breach of an implied or express term of your code of conduct, it means that such employer does not need to do a disciplinary hearing if the employer just suspects, not proves. On suspicion only. This goes against the presumption of innocence, which is protected by our Constitution, which is protected by all the progressive legal provisions under ILO conventions. If the contract provides that clause, and I know many or the majority of old contracts do have that clause. So you have got homework to do, go and check your contract of employment. If that clause is there, it has been dormant, but it's now time for an employer, if they so wish, to activate it. So they may be need to revisit common law contracts of employment. Those common law contracts of employment, they've got a death trap. They've got a poisoned well. The challenge is that when someone gets a job, out of excitement, pomp and fanfare, you don't check this fine print. There's always a saying that love is blind, but marriage becomes the eye-opener. When the time of reckoning comes, this clause will affect you. So HR practitioners, labor practitioners, we appeal to you that for us to enhance job security, there's need to ensure that for acts of misconduct, employees must go through a disciplinary hearing. There are many cases where people have been acquitted for acts of misconduct. So you can imagine this legal clause that says that you can be terminated without going through a disciplinary hearing. How painful, how unfair, how nefarious, how barbaric, how draconian, how obnoxious. Surely we need to revisit our old contracts of employment so that they also inculcate what ILO Convention 158 says, that the termination of an employee's contract of employment must only be done either through fault on the part of the employee or what is called justa causa or the operational reasons of the employer, not just an unfair termination. So this legal clause is likely to give birth to subtle, silent assassins, terminations of contract employment, and a number of employees, unless their contract employment are amended, they are going to fall victim to the common law, just like what the Zua case did. It is very sad, but it's unfortunate. The common law is back upon us and it's back with a bang. The only way to avert this avenging spirit is by exercising it in the contract of employment. Okay, the issue is, in any other way agreed in advance between an employer and an employee, where do you get that agreement? You can only get it either through a contract of employment or conditions of service. So if you blindly sign and you append your signature, you are bound. The principle of pacta sunt servanda rule, that you are bound by your contract, the one that you have signed. Caveat subscripta rule, you are bound by a signature. You cannot escape it. You can't even go to court and try to seek or to court the sympathy of the court. The court will simply enforce the contract as it is. So the wording of contracts of employment is now becoming very important. We need to make sure that our contracts of employment are tailor-made to ensure that fairness is achieved. The other major amendment is in relation to retrenchments. You are aware that Section 12C has been amended. The issue that has been brought about, the legislature has brought about the test that applies for lifting or piercing of the corporate veil, where some people or some business owners run down or do asset stripping or run a business in a manner that is meant to defraud or disadvantage employees so that they induce retrenchment. The legislature has introduced stringent legal provisions for lifting of the corporate veil to impose personal liability on the bosses. Business owners, be it in a registered legal entity or even in partnerships like us as lawyers, there are now legal clauses that are stringent, that speak to the issue of going behind and fishing out the culprit that is run down a business and impose personal liability. So that facade of being a registered company, it no longer protects when it comes to retrenchment. You also notice that the new Section 12C and 12CC of the Labour Act has completely removed the definition of minimum retrenchment package. Essentially, in a way, government has moved in to stop labor carnage by almost saying no to retrenchment. Unless you can prove compelling grounds upon which retrenchment can be made, of which employment councils and the retrenchment body, they've now been given equal powers to interrogate, to investigate, and come up even with a provisional statement that can be submitted to the Labour Court to see whether a retrenchment is merited or not. Another fundamental legal provision that has been introduced under Section 56 and 58 is to create a seamless legal relation between what used to be called voluntary employment councils and statutory employment councils. The Chunichedu mentality is gone. Government is now controlling labor with an octopus grip. The fact that they are now called statutory employment councils, potentially, if one does criminal acts or wrongs of dipping their hands into the funds of the employment councils, there's a possibility of facing criminal abuse of office. That has always been used to a lot of these public officers. The definition of statutory employment councils, it speaks to government control. This is now a quasi-government organization. So because of those legal provisions, there's room to ensure that any vices that used to obtain where employment councils are being abused, they are now nipped in the bud. But there's also a disadvantage that government may use that to clamp down on some employment councils that they may not necessarily agree with. It is a progressive provision in the sense that it can be able to restore sanity to our employment councils. The other provision, which is also progressive, is that all employment councils now have a duty to admit new members. You no longer shut the door to new members, be it an employers association or a trade union. There's been democratization of the employment councils to ensure that employers and employees have got a free will to choose to belong to these employment councils. The other point to note also is that those judgments like TEO 1, Net 1, that had said some employers could choose whether to belong to employment councils or not, they no longer apply. Government has made it very clear, the writing is on the wall, that you choose to belong to employment council or not, but if you don't avail yourself of that opportunity, you are legally bound by collective bargaining agreements because they are meant to create uniform minimum conditions of employment. So gone are the days when some employers would say that we don't want to be bound by collective bargaining agreements. Collective bargaining agreements are now of a universal application. The amendment also to Section 101 of the Labour Act that brings about review of codes of conduct periodically, it speaks to the issue of making sure that your codes of conduct at the employment council or ex-council, they are constantly revised in line with the best practices. If you don't revise them, they are automatically deregistered. It means they no longer apply and you go to the model code, the National Code of Conduct. Labor officers have also been given step-in powers in terms of disputes be it disputes that involve misconduct proceedings. There were Supreme Court judgments like St. Victor Mabeza, that was 2019, Mondana Mills versus Sakarombe. Those judgments no longer apply. Those judgments that ousted the jurisdiction of labor officers, but with this new amendment under Section 101, labor officers now have appeal jurisdiction. Supreme Court judgments, they dismembered the powers of labor officers. They dismembered Section 8 of SI 15 of 2006 by saying that once an employer has completed disciplinary proceedings, no labor officer can exercise jurisdiction, and by extension, designated agent. But with these new legal amendments to Section 101, labor officers and by extension designated agents, because they exercise the same powers, they've been given far-reaching powers. The new amendment to Section 633B of the Labor Act has given extensive powers to labor officers that I can call step-in jurisdiction, additional jurisdiction to that of a designated agent. Labor officers can now preside over matters if 30 days elapse and a designated agent has not disposed of that particular matter, which means that labor officers are now at the heart of dispute resolution in Zimbabwe. Labor officers now control dispute resolution in Zimbabwe. They've got all the far-reaching powers that entail dispute resolution in this particular country. So we need to understand and appreciate that legal provision. The other issue that I may want to comment is in relation to transitional provisions under section, under the new section 36, which is the new section 128. There's a serious gap or lacuna there in that it is only the employer who is given a right of appeal. The employee has no right of appeal. The Labor Act is saying that an employer is the one who has the right of appeal within 30 days of the registration of a labor officer's ruling or judgment, but there's no mention of a right of appeal on the part of an employee. This is potentially unconstitutional. The right of an employee to appeal has been ousted. What if the employee is not happy with the judgment? The right to a fair hearing under Section 69 of the Constitution of Zimbabwe, it has been removed. So these are some of the provisions that I'm of the view that they need further fine-tuning to avoid some more challenges in terms of implementation of the Act. The Act itself has some positives as we've highlighted, but also has some negatives as well. I have come to the end of my crash presentation. Thank you.
I'm tempted to say thank you, my learned friend. But I don't want to get the backlash. So thank you so much, Mr. Mucheche, for that presentation. There are some advantages. Key takeaway from that presentation, there are some advantages. There are some disadvantages. And yeah, there are still some areas that we may need to really scrutinize. And I think there is a lot of input that we've been given for our plenary in the afternoon. I think we still have a bit of time to have that one more presentation. Advocate will come back to look at those minor amendments, amendment of Section 120, investigation of trade unions and employers' organizations, and a few others. Another round of applause for him as he comes through.
I can start. I'm supposed to deal with 120, Section 120, or Section 35 of the Amendment Act, 36 and 37. So Section 120 brings in a provision that wants you to account for the power that we gave you. I mentioned earlier on that the conduct of trade unions, associations, and federations is now free from that much control in terms of dues. I think we talked about them, collection of dues. When you are applying for registration, we'll just allow you. We don't do accreditation, but I indicated earlier on the requirement for there to be information submitted to the registrar upon request. Now, this is another provision which, in my view, is very critical, which allows the minister to appoint. I think if you read section 121, it's made, 120 rather, it's made in such a way that if the registrar thinks that there's something wrong happening at a trade union, just like the same provision with NECs, I think in section 63A, he has power to appoint or to apply to the labor court to get a provisional, to get an administrator. Now, that provision had a clause that says the application can be made to have a provisional administrator appointed, or rather to have an administrator appointed, or to confirm the appointment of a provisional administrator. So the impression given, and I think that interpretation was carried in one of these cases at the labor court, is that the minister sees something wrong with the operations of a union. The minister appoints an investigator, which is the process that we all know. The investigator recommends that there is need for an administrator to be appointed. But before the application for the appointment of an administrator is made, the minister then appoints a provisional administrator. So by the time you go to court and the actual administrator is appointed, the provisional administrator is probably run there 6 months, and the law says nothing done by the provisional administrator can be invalidated for the reason that maybe the court eventually says that there's no need for the appointment of an administrator. So eventually, it was a provision that could allow the minister to have a provisional, an investigator who comes and says what the minister wants. A provisional administrator is appointed. They do what they want. And then by the time they get to court, the court says, no, you shouldn't have. But there are no repercussions or consequences either to the provisional or to the minister or to the registrar. Now, that clause that seemed to give the minister the power to appoint a provisional administrator before approaching the court has been repealed. So now what you have is that there must be an application first. After you've made the application, you then, if the need arises, and you think that, I think this is what we've highlighted, that you show that there is real risk or possibility that funds or property or records of an employment council, and I think that's also again something to do with drafting. Those who are looking for mop-up, they must have just copied from that provision relating to employment councils, but I should have wanted to read union or association, but you've read your clause 120, the amendment now. It's actually talking of an employment council, when in fact that is not the clause that talks about it. So it's another issue that needs mopping up. So when the property records of a union or association will be lost, dispersed, or destroyed. So when there's that risk that, well, we've applied, but these people know that the court has not granted an order, they will just dissipate things. So the registrar is now, the minister is now allowed to appoint a provisional administrator. But that can only happen after you've made the application for the appointment of a substantive administrator. So I've indicated that the old provision allowing the appointment of a provisional administrator before making an application for appointment of a substantive administrator has now been repealed. And this is what I was just explaining. Okay, let's move on to the next one. So that essentially is what 120 is about. I think this one, my learned colleagues have spoken about the transitional provisions, but they are part of the new section 36. So with this one, there is an introduction of this provision as section 128. Section 128, if I'm not mistaken, should have been the last or second from last, but it now moves to become 129. So and this is what it says. All unregistered draft rulings are automatically deemed to be judgments or rulings of the labor officer for purposes of execution. I think my learned colleague Tsitsi spoke about it, and even Mr. Mcheche talked about it. But again, there is a drafting issue. Maybe that can also be noted. They talk of registration there. The rulings by the labor officers were not registered with the Labor Act. It was not registration. ISO Kwande actually said it was. That is the first process where adjudication happens. So it was confirmation. It's different. Registration simply means that it's a clerical process where you simply say, okay, this comes from you, okay, it's fine, this is what you, it's all right. But confirmation was actually a whole new process altogether where everything is looked at. But the word used there is unregistered. But I think the effect is still there, that if the rulings have not been confirmed, then they automatically become decisions. And then it takes us again to that point which my Leon colleague, Mr. Mcheche, was talking about, that the employer only has a right to appeal within 30 days after notice of resignation. I actually think, Mr. Mcheche, that this is not a drafting problem. This is about the draftsperson wanting to be consistent. You remember Section 93, which led to the Garudzo judgment, provided that it is only the employer who could be cited in confirmation proceedings, until the Supreme Court said employer. So I'm thinking it's the same person, I suspect, who then has also said they want to give the employer. So I think this person should be from ASAS or somewhere. There should be an employer. So when I looked at it, I actually thought, no, this cannot be a mistake. This person knows that they wrote employer in 93, and it was taken right through to the Supreme Court. The Supreme Court says, no, it's pointless to exclude the employees involved. So this person has said, I'm giving a right of appeal. If employer you want it, go to the Supreme Court again. But I think Garudzo would be there. But you can't appeal now if the right is not there. And you can't use the Garudzo one, which was interpreting a provision which is no longer there. So you can't say, you know that you have to go to court. You get it anyway as an employee. But Mr. Mcheche is correct that it's an unconstitutional provision. You can't give the employer only the right of appeal. Assuming that, so the assumption here is that decisions by labor officers will only be against employers, which is not correct. I know that. Then the quantum, there's also an indication that the quantum of any determination is based on the currency of the judgment. So whatever currency that would have been indicated, employee should be paid $25,000 US. It remains as that, but it is payable in Zimbabwean dollars at the prevailing official rate. I think it was just meant to mop up on that issue. Okay, let's go to the last thing. So the last thing is the schedule of minor amendments. I think if you look at your amendment, there's a small table there. So I've just broken it down in this way. So the first one there, it replaces, so in the definition of equal remuneration in section 2, it replaces the word gender with sex and gender. So instead of saying differentiation on the basis of gender, it says differentiation on the basis of sex and gender. You then notice that those definitions of violence, sexual harassment, they just use sex and gender. So I think it's just, I don't know whether if I say gender, you understand it differently when I say sex and gender. I don't know, but maybe it's just for emphasis. So that's what happens in section 2. Then section 5, replacing again the word gender with sex and gender. So I guess that is what they wanted there, so that there is no doubt at all as to what is meant. Then section 63.2, I think this is the one that I was looking for the other time, to say, I think I know I wrote something about it. So certificates of appointment, I don't know why this is called a minor amendment. It's not a minor amendment, because certificates of appointment of a DA now restrict that DA to a particular district or province. This is not a minor amendment. I don't know why they put it. It's not minor, because you had NECs that could have one DA, the whole country. Now, the DA's registration certificate must indicate their particular province or district. So if it's national, then it's not there. So there is that amendment in section 63.2, which is the provision that dealt with the registration of DA. So it is amended to say your certificate should indicate the district or province in which you are supposed to be working. Okay, I think this is an encouragement to NECs to appoint more than one DA for an NEC. And I think that then deals with that issue that I was talking about of forum shopping, where perhaps there will be several other DAs that could be dealing with the matter. Section 104.2a, the notice to embark on a collective job action, remember it was 14 days. It has now been reduced to 7 days. So employees, instead of giving you 14 days, they can just give you 7. And on the 7th day, you know, the toy starts. Section 36, section 41A, 41C, I think I talked about this. These are the ones that reflect the scrapping of the requirement for the holding of accreditation proceedings at the registration of a union, association, or a federation. I think I spoke to those issues. And lastly, section 39.3 and section 42.1, They also reduced the time to respond to an application for the variation, rescission, or suspension of the registration of a union or association from 30 days to 14 days. Remember, I said in respect of variation, suspension, or rescission of the registration of a union, federation, or association, the accreditation proceedings still remain. But the period within which a person could respond to an application like that was 30 days. It has now been reduced from 30 to 14 days. That, in summary, is what is contained in the schedule of minor amendments. Minor, but I don't think Section 63.2 is a minor amendment. I think, let's just say that should be the end, I guess. That should be it. I think he agrees that that should be it. Thank you.
Thank you so much, my friend. My learned friend. So all the questions you've been writing since morning, it's time to discuss, and then we can finish off after lunch. And so at this juncture, I'd like to hand over to Mr. Caleb Mucheche, who will just be convening this session. A round of applause for him once again.
Thank you, Kumbirai. We must indicate that we don't monopolize knowledge. This is a new act. The views that we've expressed, these are our opinions. They are yet to be tested by our courts of law. So you are also free to give your own views, comments, or opinions so that we can cross-pollinate our ideas. I'm sure the microphone can circulate so that those who want to pose their questions can be free to do so.
Good afternoon. My name is Goddo Naringo, Safeguard Security, Human Resources Manager. So my question is around maternity leave, Section 18, the new amendment. I did not hear any presenter relating to probationary contracts. What happens in the instance where you have issued a probationary contract to a pregnant employee? I think the most measurement of a probationary contract is performance. And you engage someone who then goes on to a probationary contract. Are you able to issue unpaid maternity leave to that particular employee? Because there is no way you can pay someone on probation where the measurement for probation is actually assessment where they have to report for work. That's my question.
Thank you. I think we'll take a few more round of questions. Is there any other question?
My question is on section, on section 12, on the duration, particulars, and terminations of employment contracts. I understand we've been giving some fixed term contracts to our employees. Now I just need clarity. Are we proceeding with the issuance of fixed term contracts as guided by respective NECs, or we are no longer now allowed to give the fixed term contracts? And on the termination of the fixed term contract is self-terminating. What are the implications to us regarding the termination of the fixed term contracts, given this new law on non-termination of contracts on notice?
We'll take one more question for this session, for this round, and then we'll ask our panelists to respond, and then we'll go for another round.
Thank you for the presentation. My name is Nyanyoa from Wudo Bricks. My question is on the code of conduct. I think you said now the code of conduct, they are now reviewed after every 5 years. What will happen to the model code? Suppose the NEC code and also the common code, they are going to be reviewed after 5 years. Are you implying that like the model code is going to be static for forever, while this is the other two they are constantly reviewed after every 5 years. Thank you.
Thank you. So we'll ask our panelists to respond.
Thank you, the audience, for the question that you've posed. We are going to share in terms of responding as panelists. The issue of fixed-term contracts, nothing has changed. The proposed amendment that sought to outlaw fixed-term contracts of employment of 12 months and below was dropped last minute. So fixed-term contracts of employment, the old legal position that they automatically expire by their expiry date continue to apply. So you really don't need to worry. The position of the law is that you are guided by the number of times an employment council fixes under section 12(3)(a) of the Labour Act as amended by amendment number 5 of 2015. And also if the minister is fixed, but I'm aware that so far the minister is not fixed, the number of times a fixed-term contract of employment can be amended. I must hasten to indicate that we are now entering a time of fixed-term contracts of employment given the stringent measures for retrenchment under section 12C and CC of the Labour Act. It looks like fixed-term contracts of employment are going to be a common feature. Concerning the model code, the question that you posed, whether the model code is also subject to expiry and review, I may equate that model code to Moses' staff. The model code is overriding. There is no time limit. It's a national code of conduct. It is a fallback position where an employer does not have a registered code, either to Works Council or Employment Council. The codes of conduct that are subject to time limitation are those that are made at Employment Council or Works Council. I will defer to Tsitsi to address another issue that was posed in relation to maternity leave. Then the last issue I will defer to my colleague Benjamin.
Okay, thank you very much. With respect to the question on maternity leave, take for example, if you employ someone on a probationary contract and that person falls sick, what happens? I think that's the same position, because we are assuming that if someone is going on maternity leave and paid maternity leave, the Amendment Act mandates that every employee goes on paid maternity leave. It's not discriminatory. It doesn't matter on what employment contract you are on. So I think it goes back to the terms of the contract of employment that the employer and the employee enters in the beginning. So if your contract of employment gives, it depends on the probationary period that you are going to give to the employee. I do not anticipate an employee who comes 9 months pregnant and ready to go for maternity leave and be employed. I don't think we have such a situation, or the legislators anticipated such situation. So I think some of these issues will be self-regulatory. Unless we have a situation where somebody comes to join the employment service, maybe 6 months pregnant, and then falls into labor at 7 months. Those are separate incidents which may be addressed as case-by-case basis.
Thank you. I think part of the issue relating to codes of conduct, I think Ms. Mcheche had related to it, but I also just wanted to add and say, I think as employers, you shouldn't be concerned much about the model code. In fact, being told that your code should be reviewed in 5 years, you are, from the date of the amendment, have been given 5 years now to work on the on reviewing it, on ensuring that it is reviewed. So much such that you avoid the model code. In fact, the model code should remain as it is, as imperfect in my view as some think in terms of its outlining of offenses, for the reason that it gives you the incentive to ensure that you have an operational code yourself. If you don't renew it on time, then it falls back to the model code. So the concern that, well, we are amending ours, why is this one not amended? We want to keep it in such an unrefined state so that it gives you the incentive to negotiate your own. And remember, the distinction between these codes is that the model code is the minister who is saying, if you don't know how to come up with a code, this is what I can do. But if you are the two of you sit down and come up with a proper code, then I allow you to do so. So it is there as a fallback, like it says, but the concern of most of us here should be that let's ensure that before the 5th anniversary of this amendment, we are working already on reviewing them and not worrying so much about when it will be amended, because it, in my view, won't be amended anytime soon. Thank you.
Thank you. We'll take another round of questions. There's a hand up here.
All right, thank you very much. This is Kumbula Kelvin, HR manager from StillMed. Now my question is referring to section number 5, which is talking about equal opportunities for all employees, whether male or female. Now I want to find out if it is okay to use the power of negotiation, whereby any employee is free to negotiate for his or her salary, and then that will result in some kind of a difference in the salary scales in light of this new amendment. Thank you.
Thank you. There are some more hands.
Thank you. My name is Sekondi Muguyo from Copperways. My question is on section 12C, which is talking about the 3 levels of retrenchment packages that could be paid. You spoke of the minimum, the agreed, and the enhanced. And when I listened to the enhanced one, it's normally arrived at after some deliberations or disputes where the employee thinks they are paid more, they're supposed to be paid more than what the employer is offering. My question is there any situation where a determination will be made for the employer to pay more than the minimum? Is there clarity there where the employer may actually end up being required to pay more than the minimum? Because my thinking was the employer will be asking to pay maybe less or equal to the minimum.
Thank you. There's a hand right here.
Okay, thank you. My name is Fambai, I'm the National Employment Council for the catering industry. I've got a question regarding the case of ISOQuant, where it was ruled that a designated agent will make a determination which is final, whereas a labor officer will make a draft ruling subject to confirmation by the labor court. Yes, this new amendment amended those provisions. May I have an explanation on that?
Thank you. I hope that question is clear. Yeah. There's a hand. I think we'll take a few more.
Thank you. Maombera Manicaland State University of Applied Sciences. My question is, I didn't quite hear on when is the 5 years on code of conduct counted?
All right. Thank you. Perhaps let's take a break. I see your hands. Let's allow feedback so that we don't have too many hanging questions. Over to you.
Thank you. Let me start with the last one. When do we start counting? The law was promulgated on the what? 14th, is it? Yes, that's when we start, because that's when the statute became effective. So if your code was a 20-year code, you are not required to do it now. You have 5 years. So the 5 years start because the law does not apply with retrospective effect. Then someone asked, maybe let me deal with the section 12C one, and then I'll leave the section 5 and the ISOQuant one to my other colleagues. 3 levels of packages. The enhanced package, can an employer be required to pay more than the minimum? So if we take it back again, we say that the minimum package is just what the minimum is. Maybe we'll learn about it some other time. And the agreed package is what the parties may agree. And remember, an agreed package could either be higher, could
even be the same, could even be lower, as long as an employee is just as the parties have agreed and there's justification, that shouldn't be a problem. But the enhanced one only comes when an employer has said, I am seeking exemption from paying the minimum retrenchment package. And the employee says, no, we think that you can actually afford it. And then the discussions ensue, and therefore the decision that comes at the end of it all is a decision that is the package that is then called the enhanced retrenchment package. So a situation where an employer is saying, I can't pay the minimum retrenchment package, then an order is eventually made that you can pay even more than the retrenchment package. I think it will be a very unique one. But the provision relating to enhanced packages starts from a premise where the employer is actually saying, I can't pay the minimum and I've paid that 25%. I want to be exempted, and the employee proves that you can pay more. I think I will leave the issue of Section 5 and ISOQuant to Sitsi and Mr. Mcheche.
Thank you. Over to you.
Thank you very much. The question of Section 5, equal opportunity for all employees. The issue is on where you say our legal officer or our HR manager gets 10,000. But there are circumstances where there is a power to negotiate and circumstances surrounding the hiring of that particular employee. There are certain circumstances where, for example, you get an HR manager, say from Zambia or any other country, and automatically that requires a renegotiation because you desperately need that particular person, and within the jurisdiction you can't find that particular person, and there are issues to involving relocation and opportunities that you would have missed if not having that person in the position. So the issue that the mind behind the legislators on this aspect were that we are saying this is an HR manager, because you are a man, we are giving you 5,000, and because you are a lady, we are giving you 3,000. So that's what the legislators are trying to do away with. But it's different from a contract of employment where you indicate that this position, the salary for that position is 2,000. Whoever comes in will get a minimum, which is the 2,000. Whatever comes as an excess is due to a negotiation that happens with within the undertaking. So it doesn't defeat the equal opportunity for all employees mentality or principle that has been established in the Amendment Act. So it really goes back to the agreement that you enter with an employee. For example, you will find that there are employees who come and join an undertaking, and then those employees, maybe they get fuel allowance because they have they get transport allowance because they stay where they need transport. And then you have other employees in the same level or same grade who stay at the workplace and they don't require transport allowance. So I think that's the differentiation that comes without necessarily saying that you have breached the equal opportunity for all employees. I hope I have taken it well. And then with regard to the ISOQuant judgment, the labor officers no longer have the power to make rulings with regards to the amendment of Section 93. Whenever there is a dispute of interest, they are mandated to refer the dispute to compulsory arbitration, where they have issued a certificate of no settlement. And where it is a dispute of right, it is by agreement, either compulsory arbitration or voluntary arbitration. So the ISOQuant ruling falls away because there is no requirement for the labor officer to make a ruling in terms of the Amendment Act.
Thank you, Benjamin Tsitsia. Just to add that the powers of labor officers have been restored. If we were to do a hierarchy of authorities in labor, we will place labor officers slightly above designated agents, because what a DA cannot do, a labor officer can step in where there is a gap. So in terms of the relationship that used to exist, where DAs, according to the ESCON judgment, appeared like the superior jurisdiction, that position no longer obtains. The legislature has restored the jurisdiction of labor officers, but as it's rightly said, that jurisdiction now goes through conciliation. If the dispute is not resolved via conciliation, it goes to arbitration, either voluntary arbitration or a compulsory arbitration. In respect of areas where DAs have their jurisdiction, the legislature has not taken away that jurisdiction. It only created a step in jurisdiction for a labor officer where the DA has not acted. So you must understand and appreciate that you still have your jurisdiction within your area or within your sector as given by the legislature.
Thank you. So we go to another round of questions. There was a hand up there.
Good afternoon, Steve Harris from JVS Projects. I just have a question regarding Section 2, regarding the unacceptable behaviors. And of course, none of us want to see unacceptable behavior in the workplace. But is there a way to define what is unacceptable behavior? Because this is very open-ended and ambiguous about what any person could interpret as unacceptable behavior. And it's limited, well, it's unlimited. It's whether one instance of a line manager shouting at a guy for being late or indulging in unsafe work practices could be construed as a threat. And a guy could turn around and say, I'm sorry, I'm traumatized by that, so I'm taking 2 days off. Psychologically, are there any parameters to and guidelines regarding acceptable behaviors and what constitutes threats or actual stuff like that?
Thank you.
All right, thank you. My name is Samantha from Dawn. My question goes like, in terms of Section 18A, what then happens to the labor brokers in terms of the hourly work, especially in terms of production? Some employees can work maybe, let's say, 5 hours, depending on the production cycle. This means that at the end of the month, it can't even reach to the minimum wage. And this means that they'll be getting less than the minimum wage. What happens to that? And also in terms of the second job, as highlighted in Section 18A as well, that the employee is also allowed to work for a second employer. In terms of the code of conduct, the ones I've encountered, there's a section on moonlighting whereby it's not allowed to work for another employer while you're working on another organization. So what happens to that? Also in terms of the fixed term contracts, I heard that you said it was dropped at the end. So which are the specs now for the fixed term contracts which are specific, whereby we can stand guided if it's 3 months or a year, the minimum? Thank you.
Thank you. Yeah. We'll take a number of more questions.
Good afternoon. I'm Miri Romanadawafa, Anglo-American Unki Mines. So my question is also, I think, very much in line with the previous speaker. So I think it's Section 18A, subsection A. It talks about how an employee is allowed to actually go and work for another employer, right? But I think there was mention of an example that was given of, like, for example, DJs who work for specific hours. In cases where there's conflict of interest, or there might be like similar companies, can we have any parameters that prohibit employees from working for specific employers by virtue of the fact that the companies that they're working for have similar maybe services, or there's a conflict of interest that is involved? Thank you.
Okay, so you're saying something like you've got mine workers from Unki and then they go to Mimosa in their spare time. Yeah, interesting. Any more questions? Yes?
Right, I'm Knowledge from Steelmakers. I would like to draw your attention to Section 2, under violence and harassment, I'm a bit concerned on unacceptable behaviors, with particular emphasis on economic harm. Can it be clarified, maybe in terms of what can be done in a work context that can result in economic harm?
Thank you. I think we'll take a break from questions, allow our panelists to respond.
Tsitsi will start with the first class of questions, then Benjamin.
Thank you. Maybe I'll address the issue of unacceptable behavior. The question is, how do you define the parameters? So you notice that the test that is used in labor disputes or labor issues is a test on a balance of probabilities. So this is where we look for an ordinary, reasonable person. So we say if this conduct is to be asked to, or to be performed on an independent, reasonable person, would it be taken to be unacceptable? So you realize that even in this building, if I throw a question, the response that we get from the majority of the people is basically what is taken to be the reasonable main test on unacceptable behavior. So it's really dependent on the adjudicator to say that this behavior is unacceptable or is it acceptable. So I think basically that's it on the parameters that are set on the unacceptable behavior test.
Thank you. Just in addition on that, we are as concerned as you are with this definition. It's so wide. It's so unacceptable. It's unacceptably wide. Yeah, because it boils down, as Tsitsi says, ultimately to a reasonable man's test. Because if we ask subjectively what is unacceptable to each and every one of us, is different, isn't it? Yeah. So even as we are sitting now, someone is saying, why are they sitting? They should be standing. Someone is saying, they are tired. They should also sit, isn't it? We are different in the way we are looking at something that is so simple. So it's the same thing with unacceptable behavior. If you pitch it this broadly, it gives problems. Yeah. So I think this is one of the areas that we criticize. The problem is that I understand that most of you have codes of conduct which more or less deal with these issues. What is sexual harassment? What is violence? What is harassment? Isn't it? This you can see that all of your definitions are not anywhere near what is being said here. And the problem we have is that if in your code you are setting a standard which is lower than what is in an act, then an employee is allowed to say, look, I want to rely on what is in the act because the act is giving the right to be protected from such conduct. So it's a problematic one, and we wish it was clearer. Unfortunately, it isn't. So at the end of the day, the reasonable man's test that she was talking about then becomes the standard. And again, this is based on what that particular judge or person deciding thinks is reasonable at the time. So I foresee us having so many problems on that. I want to go to the question that was asked relating to Section 18A. I think the question was that what happens to labor brokers? What if if I hear you very well, please correct me. Your question is saying, okay, but what if it's a labor broker who is giving us the labor and the amount that is being paid to the employee gets lower than what the statute says should be paid? Is that correct? Is that your question? Because I'm saying, okay, I hope I got it correct. I'm saying what the statute has told us is that we know this has been happening, but now we regulate how it's happening. And how is it going to happen? If you give a person a contract, whether between yourself and the labor broker, unfortunately the Labor Act, the amendment didn't bring labor broking in there. So the actual employer is known as between the parties, who is the employer contractually. The statute is saying whatever you are paying them should not be, in a space of 2 months, should not be less than what they would have earned in a 1 month span. So if it is less, then it means that you've got to review, you've got to add the number of hours. So it's a subtle edge towards ensuring that people work more hours than the ones that are being given at the moment. Then there was a question, is the employee allowed to work for another employer where, say, for example, there's conflict of interest? The statute says if you are hiring a person for a few number of hours, your contract should not prohibit that person from working for another employer. That's what the statute says. So if you want me for 2 hours, don't tell me what I do with the other 6 hours. That's what the statute says. But you bring in an interesting dimension to say, okay, but what if it's Unki and then you go to Mimosa and there's a clear conflict? So it is now an issue, obviously, that will go for determination, and it will pit the following. The conflict of interest is when you sign a contract, at common law, you have a duty as an employee to save that employer and that employer alone, and not to save somebody else whose interests conflict with your employer, isn't it? So it's a common law right. It's not a statutory right. And then there's another one which gives me the statutory right to work for any person that I want, as long as you are not utilizing my holiday. So there is likely to be that conflict. And if you want to take it from a purely legalistic sense, one would say the statute prevails. But I think there is also a very great deal of conversation that can go around whether the provision can be read to mean that a person can work. Say, for example, you're working for Unki, as he says, and then the next day, or the same day you are at Unki, the next day you are at the other mining company. I think ultimately there would be an acceptance that this cannot include in situations where there's conflict. But remember what I'm saying. The statute simply says, allow me to work wherever I want. This issue of what about where there is conflict is what would be decided by the courts. So as things stand, you cannot get guidance from the statute. These are the courts that we have to relate to those issues. I don't know if there's any.
Thank you, Benjamin Tsitsi. Yeah, I agree that the definition of unacceptable behaviors is very wide. It's elastic. It's very nebulous in terms of its import. However, there is no clear-cut definition of what constitutes economic harm. Someone who was performing a job, they lose their employment as a result of that unacceptable behavior. There is an economic harm to that particular employee in terms of loss of salary or a source of living. There's also an economic harm to the employer in terms of the business, because it may actually have a direct impact, because this was an A-star performer, but because of that kind of violence, they've actually lost a job. So the economic harm can arise as a matter of evidence. It can actually be deduced. Each case will depend on its own effects and merits. There's no one-size-fits-all approach. Then Section 18A is an attempt to address the issue of minimum conditions of employment. The legislature is aware that there are some people who may not want to assume responsibility, but the law comes in to ensure that employees are not exploited. It's a provision that is meant to avoid the exploitation of employees who may actually be held at ransom. If you want to hold employees at ransom, you must be prepared to pay. That is what the law is saying. You can't keep them under a leash. You can't have an albatross around their necks without the corresponding obligation to pay or compensate for the period that you want to keep them under your control. The legal obligation is that if you marry, you must be prepared to maintain. It's when we were students at law school, I think both Tsitsi and Benjamin, they remember one quotation from Professor Oshmengue's book, Family Law in Zimbabwe. No pleasure without responsibility. Thank you.
Sorry, there's the person who asked about Section 18A, I think she also threw in one on fixed-term contracts, and I thought the question was what is obtaining. I think Ms. Mcheche dealt with that. There hasn't been any change to the law obtaining before this amendment on fixed term. So whatever was happening continues.
Thank you. Any more questions?
Thank you. My question is directed to what Caleb Umcheche raised. I think pertaining to Section 93 on the powers of the labor officer, he mentioned that there's been a restoration of the powers of labor officers. And he also highlighted the judgment of Sakarombe, that such judgments actually have been undermined by the amendment. Maybe what I may need to understand is what I recall from the Sakarombe judgment is the significant rationale or the clarification by the court that labor officers actually had no jurisdiction when it came to disputes that had been resolved through disciplinary process. It was not within their reserve. In that vein, I don't know whether the reading of the amendment where it says a labor officer to whom a dispute or unfair labor practice has been referred can be taken again to mean that the dispute may mean a concluded resolution by a disciplinary committee. I don't know whether that's what you also meant, because if that is it, it is very worrisome and stressful. If you can actually clarify that point for me, thank you.
Is that half a hand? Yeah, it's a fraction. Okay. So, yes.
I have two questions. My first question is on Section 12. What has been repealed is Section 4, Part A. And the other sections are still they B going downwards. So does that mean if someone with a contract stating they're on a 2-year contract, it's still valid for them to give notice? That's my first question. And my second question is on the definition of essential services on Section 109.
Okay, definition of essential services. All right, thank you. There's a hand here before we move to the other side.
All right, thank you. I need to get assistance in interpreting maybe this amendment document here. For instance, on page 258, there is repeal of Section 11111, which says cessation of collective job action of the Principal Act is repealed. But I'm not seeing anywhere where there is some kind of a replacement of this section which would have been repealed. Does this mean that when there is a repeal and there's no replacement, it means that law is now totally off the legal fraternity?
Yeah, that's what it means. I can answer for them. It's gone. More hands.
We see you are trying to be learned.
Yes, thank you. I have a very simple question. I'll give a scenario to make it more simple. If I'm a managerial employee, I've served the employer for at least, let's put 15 or 20 years. I decide to resign. What am I walking away with outside of leave days in terms of the law, not at the sympathy of the employer? Let's assume there's no pension fund there, and you're a managerial employee, you're not covered in the NEC Code of Conduct, so you're not entitled to gratuity. In terms of these new provisions or any existing law, what can I claim from the employer outside my leave days?
Nothing. Any more hands?
Okay, thank you so much. Mine, in fact, I'll give a scenario, maybe in the case, in the sense that maybe we have an employee whose contract lapsed on the 30th of September, and we are deciding not to renew it further, right? But in the sense, maybe by so doing, if we are planning to not to renew it, how do we communicate? That is number one. On the issue of communicating with him or her, right? Maybe you can notify him or her that upon lapse of your contract, we are not able to renew it further. But the main worry is on the issue of maybe after we have relayed the information to such an employee, he or she may sabotage work, or maybe anoshanda in a setup yekuti anomix ama chemicals to the extent yekuti he or she may produce something which is substandard due to the fact that he knows kuti akuyenda. How do we manage such a scenario or such a case?
Over to the panelists.
Thank you. Let me start with the last one. The contract is lapsing. How do we communicate? I think the starting point is that this is an issue that has not been affected by this amendment. This amendment has said nothing about fixed-term contracts, okay? And I hope that's clear, which means, therefore, that the law that obtained before remains. When a fixed-term contract is signed, a person, let's say it's a 1-year contract, a person is given 1 year notice of its termination. At law, there's no requirement for you to say, it's now expiring, it's now 2 weeks, now 3 days, please take note, tomorrow you are not coming. However, in practice, people do it out of courtesy, because to avoid this idea that perhaps a person will have an expectation. But if for some reason you forget, or you are afraid that this is a mixer of chemicals, if we tell them a week before, they will mix something that will kill us after they are gone, then you may as well conveniently forget and remember it on the day or the day before to say, remember today is ending. I'm saying at law, a fixed term contract starts and terminates on a date that is known. So 3 months is actually smaller than perhaps the 6 months, the 2 years, the 1 year that the contract is. So that has not changed. However, what also has not changed is the law on legitimate expectation. So if the employee can prove the circumstances that justify legitimate expectation, that look, this is a contract where the job is still there, these guys have actually hired somebody to replace me, and they have promised me over and over again. In fact, we were planning last week and they were saying, we're going to send you to Canada next week to go, and next week is after the expiration of the contract. So if a person can be able to do that, then issues of legitimate expectation arise. But as far as giving notice, you can't say, okay, let's find a way of telling them. If you think that it does not help you to tell them in advance, then just wait and tell them when the opportune time arrives. But you would not have broken any law on that. There was a question again, when I resign as a managerial employee, what do I get? Again, we agree that this is not something that the amendment has dealt with. So nothing has changed between what used to happen and what's happening now. I think you must understand that the salaries and benefits for managerial employees are normally negotiated. Okay, so if in your negotiation you manage to have something put in there that tells you when you go you get A, B, C, D, then you get it. But if there is nothing, so you should be aware, as Mr. Mjera was saying, when you are signing it, you know this contract does not entitle me to anything when I leave. You shouldn't then say, but those who are resigning or those who are leaving employment under the NEC are getting gratuity. What about me? You don't have a contract which is governed by the NEC. So I think let's be clear on that. Nothing has changed. Maybe let me end on this one. What happens when the section has been reviewed? I think our learned friend was spot on. It's repealed, it's gone, it's no longer there. So it's very possible that you can have a statute. I think if you look now, they are, may I pull out for you. A statute can actually just repeal a clause. So much such that we now move from section 32, section 33 to simply say repealed, and then we go to section 34. I think there are other provisions in the Act now where that is there. So there could be a repeal and replacement. But if what we have repealed, we don't want it anymore, like section 55, if you notice, which dealt with collection of union dues and the minister prescribing whatever. They just repealed everything because it's no longer our law. So it doesn't affect anything. I think I'll leave the other three for my colleagues.
Thank you, Benjamin. Just to say that, Kumbira, we've really seen your spirited efforts to become a learned friend. But maybe for today, you may take a cue from some debate that happened in our parliament when the then Minister of Justice, Emerson Mnangagwa, was responding to then Honorable Chamisa, who was still studying for his law degree, to say that I want to respond to an inquiry by my learning friend. So at this stage, you are a learning friend. Anyway, the issue of fixed term contracts, the position of the law is very clear. The writing is on the wall from day one. Any reminders, countdowns, they are not legally necessary. They are flavor. It's just a matter of courtesy or a choice that you decide to do. But given the practical situation that you referred to, our advice is that just wait for the ticking time bomb to detonate on the day that it is destined to come to an end. The position of the law is that once you have a fixed term contract, it has a date of commencement, it has also its date of expiration, sunrise and sunset clauses. So you need to not worry. Then concerning issues of to do with, I think there was another issue that was raised in relation to Section 93 powers of labor officers. There is an amendment to Section 101 of the Labor Act. So you need to understand that the message has been repeated and it has been reiterated by my learned friends here that you need to amend your codes of conduct. The amendment to Section 101, because if you read the Sakarombe judgment and also the Mabeza, St. Victor's Mabeza judgments, they were relying on interpretation of Section 101. The Supreme Court was saying that once an employer has completed disciplinary proceedings, a labor officer has no appeal jurisdiction. So government or the legislature is coming with a bang to reinforce that jurisdiction. So based on the principle of separation of powers, you must know that once the legislature is spoken, the courts cannot go against what parliament is pronounced. That will create a constitutional crisis. Your worrisome situation can be worse if this country is to get into a constitutional crisis. So labor officers' jurisdiction has been restored and government has spoken and spoken with a strong voice.
Thank you. There was a question relating to Section 4B, is it 4B, 4A, which has limited the circumstances where a contract of employment may be terminated on notice. Section 4B is clear. It just says that where an employee is given notice of termination in contract in terms of subsection 4A, and such employee is employed under the terms of contract without limit of time, the provisions of Section 12C shall apply with regard to compensation for loss of employment. This relates to a situation where the employer has given notice of termination and that employee is served in a contract without limitation of time. So nothing has changed with regards to that provision except for the limitation in Section 4A, which gives the circumstances where an employee's contract of employment can be terminated on notice by the employer. And then I think there's another question which seeks to clarify on who and who falls under essential services. As referred to in the Amendment Act, there is a statutory instrument 137 of 2003, unless there is a recent one, which is a labor declaration of essential services notice. It has a plethora of services which are regarded as essential services, and these can be found on our internet, and if you cannot find it, we can also avail it to you. But there's a lot of services which are declared as essential services.
Thank you, audience. We picked that there is a serious oversight by the legislature in respect of a question that was raised by one of the members in the audience in concerning Section 12.4a. Section 12.4b has not been repealed. But if one is to look at that particular legal provision, its relevance or application, it is also dependent upon Section 12C of the Labor Act in relation to termination of a contract employment of an open-ended nature or one without limitation of duration. So what this means is that insofar as this particular provision is concerned, one has to understand it within the context of retrenchment.
Thank you.
Good afternoon. My question relates to the submission of audited reports by employers to justify failure to pay an enhanced package. We know that audits normally happen once a year, and retrenchment may take place at any period during the year. Probably the audits are usually done by December, January, and someone is retrenching, say, in October, November, towards the next audit. And if you then require the employer to submit the previous audited financial statements, that may give a picture which is not conducive to justify the payment of a better package to the current period when the retrenchment is happening. I would have thought by audited reports, the legislature wanted to ensure that authentic financials are presented to justify a cause. But I would have thought the legislature should have said audited financials or any other relevant financial statements applying to the period in question. Then the last one was given to me by some designated agents. I'm not sure whether this is for the panelist or for the ministry, why the legislator chose to differentiate the consequences befalling designated agents and not equating them to labor officers. In section, I think it's section where complaints can be raised against a designated agent, and also a labor officer raising a complaint against a designated agent, and that foot.
Thank you.
Dave Mugarisano is my name, Africa Steel Group HR Manager. My question relates to most organizations actually subject new employees to signing confidentiality policies. What I would like to be educated on by our learned trio is whether this amendment is actually expunged these policies which organizations are using at the moment to manage theft of intellectual property, as well as conflict of interest, as the other lady from Unki over there has made reference to. Thank you.
Thank you. Any more questions?
All right, my question is on fixed term contracts, because it appears it's going to be the norm in Zimbabwe. Fixed term contracts. I'm a bit concerned in terms of designing them now. Is it necessary now to include the termination clause? Or what will then happen if, let's say, we engage an employee in a fixed term contract, 2 months, but down the line, maybe after 6 months, we feel that the services are no longer required, we want to terminate it. What is the position at law for fixed term contracts?
From what I understand them saying, the position hasn't changed. So so a termination clause will still be there because because you need to provide for, you see, when the
Thank you. Just to come to the assistance of our learning friend Kumbirai. The position of the law as regards protection of fixed term contract that was brought about in terms of section 12(3)(a), which was introduced by Labour Amendment Act number 5 of 2015, that gives employment councils the power to come up with number of times fixed term contracts employment can be renewed. It still remains legally valid. So you must make sure that when you employ people on a fixed term contract, read and understand what cap has been put by employment council. If by default you don't follow that cap, that fixed term contract mutates into a permanent contract employment, and you have the legal obligations that are attendant to it. So you need to always check with your employment council, what cap have you put, what is the system that you have put in terms of the number of times a fixed term contract employment can actually be renewed. If you don't follow that provision, by operation of the law, you actually be bound. So you must always be on the lookout Then concerning issues to do with termination or notice for fixed term contract employment, the amendment under section 204A, which was given fixed term contracts as part of termination notice, it has been repealed. What the law now provides is that an employer can only be able to terminate or notice for misconduct. And that provision must be there in your contract employment. If it is not in your contract employment, you cannot. If you terminate prematurely, you must pay an expired period of the fixed term contract. You must make sure that you prepare to compensate the employee for the remainder of the fixed term contract employment. So there may not be need for an employer to make such an unwise decision. You must understand that if you do a botched dismissal of a fixed term contract employment, you pay someone while they are seated at home. There was another question that was raised in relation to confidentiality of information for the employer. I will refer you to a Supreme Court judgment in a case that I did for Tamaniko and others, Zimbabwe. It's a 2017 judgment. The Supreme Court said that an employee who refuses to be bound by a confidentiality clause in an employment relationship must be offloaded. The Supreme Court was very, very hard. It's like what happens at Mbari Musika. The Supreme Court said no employer can keep such an employee. Confidentiality issues, they are implied even if they are not written in your contract employment. Surely, which kind of employer would want to keep a WikiLeaks?
Someone asked about. I think this is a question that was given to them by a DA to say, why are you differentiating the consequences for a DA who has non-performed with those of a labor officer? I don't know if it is here. I remember coming here sometime or somewhere where I said, the understanding, I think Mr. Mcheche captured it well, to say, if you do a hierarchy now, the labor officer sits at the apex, and the DA is some branch manager somewhere. So the powers that the DA exercises are powers that would have been exercised by the labor officer. But the law says, let's give you someone who can manage the Mutare branch, because you can't be everywhere. But if you realize that your branch manager in Mutare is running your bank like a rival or something, you can always call them back to say, but that is not how we do things. So I think this is the same principle here. The DAs are given powers to act on behalf of labor officers in the specific industry that they are operating in. But if you are there, you are not doing inspections. Disputes are coming and then you are ignoring people and so forth and so on. It means the essence of having an employment council and having a DA to deal with the dispute there is defeated. So the legislature is saying, let's bring it back. So for me, it's a check on NECs to say, understand your primary mandate. You are there to save the industry. And that is why you are given the mandate. A lot of DAs were happy to say, look, we can now do determinations. Labor officers cannot do it, enjoying the power to decide matters. But that is not your only job. Your job is to inspect. Your job is to be there. That's why the statute says within 30 days from when the dispute arose. I indicated earlier on that it should have been from when the dispute was referred to the labor officer. But with hindsight, maybe the legislature is saying, look, this is a DA or this is an NEC which should have inspectors or people who are going there. So they should know of a dispute the moment it happens. So if they are not working well, the owner of the power it's delegated power. The one who delegates can always recall and say, but this is not how I would have done it had I been there. So, and I also want to believe, Mr. Norway can attest that labor officers have their own mechanism through which the provincial and senior offices regulate how they perform. So if there is a dispute or if someone is complaining about a labor officer, I want to believe there is a way through which that can be done. But here, it's arising from situations where, for example, a DA is doing what they're doing, but either the NEC, the council itself is doing nothing about it, the general secretary is doing nothing about it, and the law is saying, hey, I think let's do it ourselves. Now, you will find that it may be one clause that will be used very sparingly because DAs know, and the NEC, general secretaries and council know that once you start having the labor officer coming to us and saying we are taking over cases, the effectiveness of that NEC is already under scrutiny. So it's something that also puts the NECs on guard to say, let's make sure what the DA is doing. Councillors should not just come, sit and get allowances and go back without getting a report that speaks to what is the DA been doing in inspection-wise. What is the DA been doing? How many cases did she or he receive? How many did he or she finalize? How many are at different stages? Something like that. I think the same process that happens for judges now. When you get a case, you must give a report. I got it on this day it was postponed. Was this a good reason? Yeah, something like that. That is what is expected by the law of the DAs and the respective managers in those institutions. So the differentiation, I think, is for a good cause. Someone asked about audited reports and said, look, audits are done yearly. Why are you asking for audited reports? Say, for example, we are retrenching in November, and then you ask for audit reports that was done for a period of the preceding period. The statute says we want audited financial statements. The statute did not say bring audited financial statements, full stop. Okay? So your starting point is what the statute says. This is the statute. I have given you the audited financial statement. But take note, we are 9 months away from this audit. These other things have now happened. So I don't think there's a limit as to the evidence that you can give. But what you can't do is to bring us your management accounts and not bring the audited statement, which the statute wants. So do what the statute wants, but since this is an inquiry where you're supposed to justify why you are alleging incapacity, you can go as far as you want. So it's for you to say, this is just a starting point. And the converse of your example can actually happen, where the situation was dire according to the audited financial statements. But as things stand, the employee will be saying, no, you signed this contract, you opened this other plant, all these things which were not there at the time of the audit. So much such that you'll be the one wanting the audit to be looked at, full stop. You don't want anything else to be considered. So it's something that goes both ways. The employees will say, yes, you have brought an audited statement, but it is for the previous year. What we know has happened in the past 6 years is this. You can't say that this company is ailing. So I think let's understand that this is just the starting point, but it's one that the statute specifically requests. I think we have dealt with all the questions in this round.
Maybe if it's here something to add, but I just want to also highlight and underscore that the amendment of powers of labor officers is a very progressive legal provision. Labor officers are a 4 big position. Labor officers represent government. So you can imagine if there are disputes that are unresolved, what do members of the public say about the government? They will raise complaints. So this is why government has said that if we give you an opportunity and you don't exercise that jurisdiction, we take it back because it's a delegated function. Employment councils perform the delegated function of the minister. Labor Amendment Act number 11 of 2023 has reasserted the powers of government in terms of labor dispute resolution, which is very progressive to prevent a situation where some DAs may sit or delay resolution of matters, and that has got a very ripple effect in terms of the industry.
Thank you. My question is on collective bargaining agreements negotiation. You'll notice in amendment of section 25 and amendment of section 74, there is that bit where the minister responsible for that body, corporation or entity shall be deemed to be a party on an equal footing with such employer and accordingly is a party to the negotiation of such collective bargaining agreement. At what point does the minister stop? Coming from a point where we are saying the minister or the parent ministry is the employer's employer. So if the employer's employer is also part of this bargaining agreement, say there's a dispute between the employer and the employer's employer, what voice stands at the end of the day? Because the employer is coming from, if I may loosely call it, an informed position, and the employer's employer may be coming from a political position. So where do we stop? Where do we draw the line, firstly? Secondly, are we also then saying if it is an equal footing, if the employer is not there and the minister is there, the negotiations can proceed? Or if the minister is not there and the employer is there, the negotiations can proceed? And then thirdly, since in these collective bargaining agreements, there has to be an equal number of employer representative and employee representative, What are we then saying now with the addition of the minister? Because the scale is no longer balanced. Thank you.
Thank you, and then we'll get these last two, and then we close.
How feasible is it that you get negotiated financial statements from companies in Gaza, like Barry, so I think it's a well fact that most of the companies that make this more or to media. How feasible is it to produce like audited financial statements from these CNRs employees?
Thank you.
I could just give an example. Like we've got an employee you've employed and they pass probation. So we normally then give out a letter confirming them to permanent employee. And normally the termination clause will actually then highlight to say you've got 3 months notice to terminate by either party. This is for a permanent employee, not a fixed term, 2-year or whatever. Are we going back to then say you have the option of terminating on 3 months notice on your part, and then I then specify to say then for the employer, we will terminate you if there's a disciplinary hearing, like the wording, because literally we've got some employees that we need to then confirm to permanent as from August. And I'm trying to ask myself, how are we going to word that in the contract to say you've been confirmed to permanent, but yeah.
Thank you, audience, for raising very fundamental questions. Really, this is amnesty time. The issue that was raised in relation to powers of the line minister for quasi-government institutions or corporations or state-owned or state-controlled entities, the involvement of the minister, there's a background to it. There are some wage bills that were raised in eyebrows, where government was querying to say that how did this wage bill come about. So to address that particular challenge, government is now coming to also be involved to participate. There's also a concern that some employees were raising that we have principals who run these parastatals or state entities, we have no mandate. There's no point in going through a collective bargaining, which is like an empty noise without any result. So the involvement of the minister can actually ensure that there is a result that can actually come about. There was also a concern where government was saying that some of the bosses within these state-owned enterprises were negotiating for themselves. They would inflate figures so that they also benefit behind the scenes in a situation like conflict of interest. So the involvement of government in terms of negotiations, it is also there for purpose of checks and balances. Surely we can't run away from the fact that political force is also going to be involved. But at this stage, we can't tell the direction of the wind. Maybe it's going to be positive. We can't be prophets of doom at this stage. Over to you, Benjamin.
I wanted to be a prophet of doom. I've just been restrained. Someone asked about financial statements, audited financial statements. Kwasiaso, what happens? I think Mr. Stillmate here can tell us. They are somewhere there, but they are doing things the correct way. So this is the thing. If you want to pay less than the package, the law requires you to give us proof that things are not working for you. And the requirement are audited financial statements. So if you don't have them, don't even dare. Just pay. Because if as an employer you are poor, but when the law says prove your poverty by showing this, you are so poor that you can't even afford that which the law says you should, then just pay. Because you won't be able to just, because I'm imagining sitting in an exemption committee or retrenchment board, and a person says, yeah, I have everything else, but I don't have audited financial statements. And the other side from the employee will say, no, but the statute says they must be there. So if you have not given us the audited financial statements, that's the end of the story. So that's why I said, even for you to move from the statements to something else, as my colleague there was talking about, you have to have a starting point. And the starting point is what the law says. So if you don't have that, I'm afraid you won't be able to get an exemption, number one. Number two, you won't be able to perhaps justify you paying something less if the employees are the ones going to say you should be paying more. So I think that one should not cause us problems at all. Since you want to take the termination one.
Okay, I see that, my sister, your worry is more on 3 months' notice. Put it in the contract of employment. Because the Section 4A states that termination on notice can only be done by mutual agreement in writing. But most employers, they don't want to give employees written contracts of employment. But written contract of employment is the only proof that we have agreed on these terms in writing. So if you give your employee that permanent, a letter of appointment is not a contract of employment. Most employees, they have a letter confirming that they have passed the probation and they have been offered an opportunity to serve the company on a permanent basis. But that is not an agreement in writing. So you need to reduce every terms of employment as required by Section 12 of the Labour Act. The duration, the address, all the details that are required. And in that contract, that's where you put that that's where you indicate the termination clause. So you would state that this contract of employment shall be terminated on 3 months' notice given by either party. And you go on further to say that should the employee fail to give the required notice, A, B, C, D will happen. Because we've seen a lot of employers coming to our offices to say, but this employee has just left. In our agreement, we have agreed that she will give us 3 months notice, you give us this much notice, but they have just left. But what have you put in your contract to say if they don't comply with that provision, you are going to withhold, you are going to do A, B, C, D. So the fallback position, which is the most dangerous position that has been inserted in this amendment, is that contract of employment may be terminated on notice by mutual agreement in writing. And this agreement is entered when the relations are still good and the employee is so excited that he has been offered this opportunity to be in this company. So I hope I've answered your question, my sister, on Section 4A.
Yeah, before Benjamin comes, I think we did highlight that there is a red light flashing around Section 12. Surely that common law termination or notice is back, but it can be averted by employers and employees trying to limit circumstances under which termination notice can be done to restrict them to misconduct. Situations of misconduct where someone has committed an act of misconduct. Where someone has not committed an act of misconduct, if we remove job security, it can be counterproductive. I appeal to all of us here, the legislature has given us freedom of choice. But we know that there's no equality in the employment relationship. There's economic dependence. So during that period when there's pomp and fanfare, someone wants to sign a contract, they simply sign. But I may also indicate that this new clause, Section 12, it is potentially unconstitutional. It may actually amount to a violation of the right to fair labor standards as provided for in terms of Section 65, just and equitable conditions of employment, because from the wording of it, it presumes equality. And yet, if you read the Greater Men's Constitutional Court judgment, it was premised on the fact that there is no equality in the employment relationship. The Constitutional Court justified the backdating of Labour Amendment Act number 5 of 2015 because of lack of equality. But this clause seems to suggest that there is equality. Now, like I said, a good precedent gives birth to a good precedent in future. If it is also a bad precedent, it may also equally affect. So let's try to come up with the better conditions of employment. By the way, the Labour Act offers minimum conditions of employment. You can give better than the Labour Act. The legislature is trying to encourage parties to come up with something that is better. Let's also look at international best practices so that at the end of the day, we don't have a relationship that is characterized by some kind of a submarine mentality. You are ambushing one another. It's a try and error game. We are of the view that as employers and employees, try to ensure that your contracts of employment, they are worded in such a way that fairness prevails. Over to you, Benjamin.
Thank you. I was just going to say to my sister there that if you look at section 12.4a, the B part, so the A part says by mutual agreement in writing. The B part says for the breach of an express or implied term of a contract upon such breach being verified after due inquiry under an employment code. Or my view is that, as Ms. Mcheche says, it's a subtle termination or notice that is built. That should have been paragraph C, which says, in any manner agreed in advance by the employer and employee consent. That means if you put it in a contract, it's okay. So that's why Ms. Mcheche is saying, let's exercise this trend, because as things stand, we seem to have actually brought back what we had removed by the 2015 amendment. Thanks.
Thank you. I think everything that they've said, I was also thinking, so I'm not far off from being a learned friend. Thank you so much. Now, in conclusion, would like a few brief remarks, given our time, from our Provincial Labour Officer. Thank you for being with us. Just your comments on the workshop that we've had, but in a very short space of time. A round of applause for him.
Thank you so much, Mr. Kumbi, for the time. I don't think I've got much to say, only to say that I enjoyed the presentations. Of course, I think I've heard enough noise on the aspect of the minister being on equal footing, especially with regards to parastatals. I think I've also heard enough noise on the concern from most DAs to say, why is it that the labor officers seem to have been raised a bit? You see, like it was indicated that yours is but a delegated function. So you'll find that in some countries, dispute resolution is entirely for the ministry, for the central government. But in our case then, that power or that responsibility has been delegated to our employment councils. So I think then they should understand and appreciate that. And at times we do find that an employment council will have one DA, say in Bulawayo, right? And then there are companies in Harare here. Then when we attempt to accept their disputes, the DA will say, you don't have jurisdiction. And you can imagine what will happen to that type of employee. So otherwise, thank you so much for the presentation. They are so nice. I just hope our good presenters will make us access their presentations for future references. Otherwise, that's all I can say. Thank you so much.
Thank you. And a 1 minute vote of thanks from ACE's chairman, Eastern Region, Christopher Mushiwokufa.
Thank you very much, Kumbi. On behalf of the ASAS team, I would like to thank everyone, every delegate that has managed to be in this place. It was a quite fruitful discussion, an eye-opener, and I'm sure our conference presenters would wish that if this room was full of lawyers, they would be participating or in answering the questions that we were posing to them. To Mr. Matthias Ruziva, thank you so much for organizing this conference. It is quite informative. To Mr. Tigere, thank you for supporting the team. The incoming president, Mrs. Chigombe, thank you very much. The conference speakers, Advocate Magogo, Mr. Mcheche, and Ms. Mazikana, thank you very much. We hope and wish we'll have another round of discussions with regards to the changes that have come through. The Provincial Labour Officer, thank you again for supporting us. The academia, the industry at large, the employers, the trade union officials, thank you so much. You have made this conference a huge success. We have gone back to the basics in terms of the industrial relations climate, having the government, the employers, and labor there. Thank you so much. We would like to welcome you back once again. Thank you.
Thank you so much. And we'd like to just thank ASAS for this opportunity. And they want to advise us that their sister organization, the Strategic Leadership Association of the Zimbabwe Iron and Steel Industry, is going to convene an annual HR Leadership Summit in October. Invitations will be sent to you. And we would like to just thank once again our sponsor for today, EMF. A big round of applause to them. May I ask Mr. Benura from Air Zimbabwe to give us a closing prayer. A round of applause for him as he comes through.
Let us bow our heads and pray. Precious Lord, we want to thank you for this workshop. We want to thank you for the presenters. We want to thank you for every attendant who has managed to be here. Father, as we leave this place, we pray for traveling grace back to our different places of work. Thank you for being with us. Thank you for the insightful contributions that came up from everyone who was present here. We thank you as we dedicate this time over to you in Jesus' name. Amen.